Good morning and welcome to the Appellate Division, First Department. My name is Justice Sally Manzanet Daniels, and I will begin the call of the calendar. People v. Robert Mitchell.
Attorney Megan Byrne for Mr. Robert Mitchell.
Good morning. You've been granted 6 and 2. Mr. Anderson.
Yeah, Paul Anderson for the people. Good morning, Your Honor.
Good morning. You've been granted 6.
Thank you.
DePepin versus Berrick Management. Mr. Pagano. You've been granted 4 and 2. Respondent, Mr. Isaac, you've been granted 5.
Thank you, Your Honor.
R. Khalil versus Evans D. That case is submitted. Levy versus Key Food. Mr. Kaufman, good morning. You've been granted 4 and 2.
Thank you.
Mr. Steinberg for the respondents, you've been granted 5.
Thank you.
Albuquerque versus City of New York. I hope I don't mangle the name. Mr. Tatich?
Tadich, yes, that's correct.
Tatich, very well. 6 and 2, good morning to you. And
Thank
Mr.
you.
Isaacs, you've been granted 5.
Thank you, Your Honor.
Agoli versus PS Contracting, Mr. Murphy for appellant.
Yes, good morning, Your Honor.
Good morning, you've been granted 4 and 1. Ms. Deeth for technical, you've been granted 5.
Thank you, Your Honor.
And Mr. Sue for Zoria, you've been granted 3.
Thank you, Your Honor.
Good morning. People v. David Gant. Ms. Myers.
Good morning.
Good morning. You've been granted 5 and 2. And Mr. Comanadira, did I say that right?
Mr. Commandoria.
Commandoria. I will attempt to say that correctly next time. 5 minutes. Good morning.
Thank you, Your Honor.
Ms. Cohen on Eagle Hill versus FPCG. Ms. Cohen, you've been granted 5 and 2. Good morning.
Good morning, Your Honor. Thank you.
And respondent.
Travis Tatko, Your Honor. I'd like to introduce my colleague, Colin Hagan, who's been admitted pro hoc. We would request that he argue this morning, Your Honor.
That application has been granted. Thank you. And welcome, Mr. Hagan. You've been granted 5.
Thank you, Your Honor.
Gurney's Inn versus Azranipur is a submit. CAS Marketing and Licensing versus J. Franco and Sons. Mr. Ruskin for the appellant.
Yes, Your Honor.
Good morning. You've been granted 5 and 2.
Good morning.
Mr.
Thank you.
You're welcome. Mr. Pincus, for respondent, you've been granted 5.
Thank you, Your Honor.
Good morning. Mayor versus General Electric. Mr. Martinez for appellant.
Good morning, Your Honor.
Good morning. You've been granted 5 and 2. And Ms. Quitt, you've been granted 5. Good morning to you.
Good morning, Your Honor.
R. Ivan versus Lysandra F. is a submit. Brown versus City of New York is a submit. Sacco versus NYCHA is a submit. People versus Michael Wayman. Appellant, Ms. Wolf.
Good morning, Your Honor.
Good morning. You've been granted 5 and 2. And for respondent, Ms. Carlson, you've been granted 5.
Good morning. Thank you, Your Honor.
You're welcome. Coronado versus Viola North America, Mr. Isaacs. Appellant, you've been granted 5 and 2.
Thank
And
you.
respondent, Mr. Fixler, you've been granted 4.
Thank you, Your Honor.
Bento versus Dormitory Authority is a submit. Mezaneff versus Tashi Bekov. Mr. Mezaneff, good morning.
Good morning, Your Honor.
You've been granted 5. And Ms. Brennanson, for respondent, you've been granted 5.
Thank you, Your Honor.
Samlal versus Ganbarpur is a submit. First case on the calendar, People v. Robert Mitchell. Ms. Byrne, you may proceed.
Good morning, Your Honors, and may it please the court. Megan Byrne for Mr. Mitchell. Mr. Mitchell's case was an extremely emotional case. This was a case that involved the death and shooting of the death of two teenagers. So unsurprisingly, the audience was also very emotional throughout the trial. They were disruptive and multiple times had to be told by the court to either quiet down, not to make faces, not to make noises, multiple things like that. So this made it particularly concerning when, during deliberations, the jury, the foreperson, asked the court if there was some way to accommodate the jury in not having to interact with or encounter the family members of either the defendant or of the deceased after their day of deliberations. So the foreperson went to the court and said that the previous day after deliberating, the jurors were concerned because no matter how the jurors left, at some point they were with these family members, either in the elevator, in the courthouse, outside the courthouse. And so the jury was asking for some kind of accommodation to make sure this didn't happen. He said that they were concerned and they were upset by this. So at that point, the court had a duty under Buford to make an inquiry, at the very least of the foreperson, but really of all of these jurors, to see, one, what these interactions entailed, how they affected the jurors, whether they affected their ability to be fair.
If I am correct, both the people and the defense consented to the court speaking with this jury foreperson alone.
To be clear,
so there's no way for anyone to say that the court did not engage in the kind of questioning of this foreperson that you are referring to.
I want to be really clear about what was consented to here. So the jury had submitted a note earlier in that day asking for transportation. The court said, no, we can't do that for you. Then the jury submitted another note that said only a juror wants to speak privately with the court. It didn't say what it was going to be about, that it was re-referencing this transportation issue. So that was what was on the table. And both the prosecutor and defense attorney said, sure, if the juror wants to speak to you alone, we'll let that happen, and then you can tell us what it was about. After that discussion, that's when they found out it was about the issue of all these jurors leaving, feeling uncomfortable. And that's when the defense attorney and the prosecutor made separate requests that the court here make a inquiry of the jury. In fact, there were 3 requests made after the lawyers found out what happened in the robing room and what that question from that juror was about. First, defense asked that we at least make the audience leave and question the jury as a whole in the courtroom altogether, all the jurors. And then there was a break, and that was denied. Then there was a break, and the prosecutor separately said, actually, you know what, I'm going to have to request that you, in fact, ask each juror to come, person by person back into the robing room. I think that's what's most appropriate here. The court denied that.
Ms. Byrne, this is Judge Singh. Wasn't the foreperson's concern about unnecessary gatherings and contact between both family members of both sides? Wasn't that just the concern? So why couldn't the court hear it out and then sort of make the necessary accommodations so that there wasn't that contact? Why wasn't that sufficient under the circumstances?
A couple of things. One, the foreperson was, in what he said to the court, spoke of all of the jurors, no matter how they left, having these kind of encounters. So, I mean, because the court never asked these other jurors what their encounters entailed, even assuming that he's right, and I'm not sure the record supports this, but assuming he's right and the foreperson wasn't concerned, we don't know what these encounters entailed. We don't know whether, just as they had in the courtroom while court was going on, the audience members said things or made, like, what kind of noises they made, words they said, anything like that, because the court just simply didn't inquire. So as to at least the other 11 jurors, we don't even know what those interactions, had. And, in this way, and the second thing is the court did not accommodate the jury. The jury, yes, first asked for transportation, and then proving this was not about transportation, then said, okay, so if you won't give us transportation, will you at least do something where we get to leave before the jury does? And we don't have to.
And quite frankly, counsel, that's something that is done as a matter of course in most courtrooms. Certainly back in the day when I had trials, I would do exactly that. Hold the audience back until the jury had a chance to leave, precisely to avoid getting on the same elevators, seeing each other at the exits and entranceways to the courthouse, just to avoid even the appearance of impropriety. So why was that solution not adequate in light of what was communicated to the judge?
I think that's absolutely an appropriate thing to do. I think two things. One, it would not rectify whatever encounters had taken place the day before. And again, we just don't know much about it because none of these jurors were asked about, especially in an elevator. Given this record, given how emotional and loud and understandably very into the case these families were, we don't know what was said in such close quarters. So it wouldn't have rectified that. And the second thing, and most important thing, is there's no indication that the court ever did that. The court never said, like, okay, well, at least I will do that, even though I can't give transportation. And reading the record, there's no indication of him saying, okay, so I am going to make sure that you do go out before the audience goes out. I'm taking this seriously for that. There's no indication that ever happened. And certainly if the court had done this as a matter of course and had done that the previous day or the days that followed.
Well, is there an indication on the record by either the people or defense counsel that notwithstanding this juror's request that the court did not heed that request? Is there anything on the record by either of you?
That he didn't heed?
It seems to me after this issue, and both sides are asking for questioning of the jurors, that had the judge done nothing, as you are suggesting now, that would have been placed on the record. Is there such a statement on the record?
There's no statement on the record that the court didn't do that, but the court, when he denied 3 times this request, never mentioned, didn't discuss at all the holding back option, and said, this is a question about transportation. They're asking me about transportation. It has nothing to do with the case. The foreperson didn't even say he was upset. These are the reasons for his ruling. So I think that, coupled with the fact that there's no indication that he held them back, and we know that he didn't the day before, I think speak to that. And again, it wouldn't have rectified whatever these encounters were that had already happened.
Well, counsel, this is Judge Scarpullo. Did any juror actually say anything? Did any juror make any indication that any of the people that they encountered in the elevator actually spoke to them or did anything inappropriate? Because all I saw from the record was what the foreperson said, and you're asking us to assume that other jurors said something else, that there's no indication on the record is true.
No, Your Honor, only the foreperson was able to speak to the court because the court didn't ask any questions of the other jurors. So I don't know.
Wait a second, counsel. This is Judge Scarpullo again. Every juror has the right to write a note to the court and say, this happened. And the fact that one didn't doesn't mean that we should, that means that there's no indication that any did. You can't ask us to suppose or speculate that anything more happened than what was actually on the record. And there's no indication that any juror said anything other than what the foreperson said.
Well, unfortunately, we don't have what the
elevator with them.
We don't have
answer that question, and then your time is up.
Sure, sorry. We unfortunately don't have what the foreperson actually said on the record because this was just the court relaying what he said. But he did say that all of the jurors were upset and concerned, and no matter how they left, had these interactions. So I think that one sentence could not have possibly have summarized what happened, and the court should have inquired to see what the minutiae of those were.
Thank you so much. Mr. Anderson, you have 6 minutes.
Thank you, Your Honor. Good morning, and may it please the court, Paul Anderson for the people. The judgment here should be affirmed in all respects. As the Court of Appeals has recently affirmed on Tuesday, we view this decision not to inquire further under an abuse of discretion standard here. And that's because the trial court, is in the best position to evaluate the jurors, evaluate the situation, and craft a procedure or remedy in which that will limit the intrusion onto the sanctity of the jury process. Well, yes, it can be unfortunate for a reviewing court not to have a full fleshed out record. The Court of Appeals, once again.
Counselor,
Yes, Your Honor.
isn't some concern that where both sides are asking for the inquiry and the court denies it? Isn't that something that we should take into consideration, that both sides thought it was important enough that there should have been some questioning of the jurors?
Well, the people's application was after the lunch, and it's plain on the face of the record as an ounce of prevention. But if we make a rule that if both sides ask for it, that completely strips the trial court of any discretion whatsoever. And here, the trial court is charged with maintaining the sanctity of the proceedings, making sure that deliberations go forward uninterrupted here. And here, what the application was for wasn't just, can we please have that one conversation on the record again? It was, let's get all the jurors out here one by one by one. It wasn't only until after lunch and hours later where the defense attorney said, well, can we at least put that on the record? So here, when the judge was presented with a procedure that would have interrupted the entire proceedings, probably amplified what the court itself was able to observe the jury foreman, thinking that this is just probably an unfortunate, awkward moment. And to the extent that defense counsel now argues that there was no procedure remedy done, once Your Honor noted that no party made an objection, that nothing has been done. On 1658 of the trial transcript, you can kind of see the court officer or the judge telling, please follow the sergeant when he dismisses the jury. So there is some evidence that the court took these logistical concerns into account and addressed them. And if we look at the content of
Counsel,
the note,
follow the jury is not any indication that there was some instruction that was being followed. I'm sorry. That's said every single time there's a recess. Every single time a judge says to a jury, follow the court officer.
well,
So
Your Honor,
that does not prove that something was done unless it's clearly stated on the record.
well, once again, then an objection should have been made, or a reminder from defense counsel of, oh, Your Honor, can we make sure that witnesses, can we hold back the audience? Can we do this? None of that was put on the record because it appears that the court followed the logistical instructions. And to go back to what the actual note said, this wasn't in terms of, can I talk to the judge in private? That wasn't the only thing on the note. It was, can we please see the evidence into the jury room to assist in deliberation? Can we also get Detective Donovan's full testimony, both direct and redirect, with the reporter reading a little slower? And then at the end, like nearly as an afterthought, may one of us please speak to the judge in private? And this is after a previous note.
Is under our precedent, is this decision by the court one that is subject to harmless error analysis?
Under this court's precedent, no, under Ventura and Shaw, but under the Court of Appeals precedent, there is no freestanding constitutional right that would to a Buford inquiry without dismissal of the jury. As I addressed in footnote 19 of my brief, when this gets the Court of Appeals case that was relied on for that proposition, People v. Anderson, that only addressed the issue of when a court dismisses a juror without conducting any inquiry. That the Court of Appeals says deprives the defendant the constitutional right of the jury of his choosing. Here, this is just without something more, such as a showing of prejudice or that he was somehow tried under an impartial jury. This is something akin more to a 330 sub 2 motion in which you have to show that there was no impartial jury. And we see this litigated often in habeas claims, federal habeas claims. And as I noted in Garraway, the Northern District case, that once again affirmed there is no freestanding constitutional right to just an inquiry on its own. And so here, without something more saying that such as the jury itself is actually impartial. So here, when we have the court who was in the best position, this isn't like Ventura in which the trial judge was listening to the court officer's summary of what the jury told him. The judge had, on consent, had the jury foreman in front of him, evaluated his credibility, and in light of the note about transportation before, and then as the record even goes further after that, they asked again for transportation, or they asked more about how to get home sooner because of their childcare issues. So once again, the logistical aspect was really the driving concern here, rather than any allegation of undue influence or bias here. And if your honors have no further questions, I'll yield my time. Thank you.
Thank you so much. Ms. Byrne, you have 2 minutes.
So just to be clear, when the prosecutor did request an inquiry, he requested above and beyond what defense counsel had already asked. He said, actually, I think individualized inquiry is more appropriate. So this wasn't just a check your boxes kind of request from him. And I want to also note that here we know that one of the jurors, Juror 4, had said during voir dire that she felt that the number of people in the audience, that the people in the audience would possibly affect her. She was later rehabilitated, but I think that is relevant when we think about how these people might have been affected. Regarding the case law, this case is akin to People v. Ventura, where all that happened there was the jurors were in an elevator with the defendant. There was no evidence in that case that anything was said in the elevator, but this court found that it was proper that the court give an inquiry and ask the jurors if they were affected by that. And Also, in People v. Ventura, this court said that where a juror said she was just invited to a breakfast that the DA was going to speak at, and she felt fit to mention that there should have been an inquiry and reversed when there wasn't. Regarding the harmless error analysis, the Buford inquiry for which this inquiry is named in Buford, the Court of Appeals says, CPL 270, these statutes are enacted to protect the right to an impartial jury. So the constitutional right here, of course, is the right to a jury. And if your honors have no more questions.
Thank you so much. DePepin versus Barrick Management, Mr. Pagano.
Good morning, Your Honors. May it please the court. The question presented is whether the video presents sufficient evidence to connect plaintiff's fall on the stairway to the alleged defect with step number 10, which was a worn front edge. Before addressing the video, I would like to briefly talk about what we do know as a potential cause of plaintiff's fall and the prior use of this stairway. Plaintiff had a significant medical history. She had been hospitalized for dizziness and vision loss. She was suffering around 4 times a week, and she had a history of neurological imbalance and falls.
Counselor, this is Judge Singh. Counselor, sure. What you're asking us, it seems to me, to sort of weigh the evidence and say the fall may have been caused by what you're raising with respect to her historical condition, with her medical condition. Is that appropriate for us to consider?
Well, Your Honor, it's just as appropriate, I would think, as what they're suggesting the video shows, which I'll get to.
Okay, but that's not quite accurate, because you also have an expert's affidavit.
I do.
And the affidavit of the expert says what he believes it shows, and then he gives an opinion with respect to step number 10. Right?
Okay, we have an opinion from a neurologist, Your Honor, that doesn't conclusively say that her fall was caused by her medical condition, but he does render an opinion that it may have been caused by that pre-existing condition. She may have had a stroke.
So isn't that a jury question? Isn't it a jury question? You'll put the neurologist on, and he'll say maybe it was this, and the expert, the engineer, will testify as to what he says, and then the jury will weigh it and make a decision.
Well, I'll get right to that point then, Your Honor. It's clear that you appreciate my argument on the medical condition. I'll get right to the argument on what their expert is supposed to say on this. So my point is that let's turn to the video and look at what it shows. No doubt it shows that the plaintiff fell down the stairway, but I submit it does not show where exactly plaintiff fell on the stairway or what caused her to fall, and certainly not with any reasonable degree of precision or clarity. At best, it's inconclusive. And the plaintiff's position on causation hinges on the affidavit of an engineer expert.
Isn't that true about all of the evidence here?
Excuse me, Your Honor?
Isn't that true about all of the evidence before us? Your doctor's opinion, the engineer's opinion with respect to the plaintiff's side, it's all opinions, speculation as to what it may be, what it may prove, and isn't that precisely what goes to a jury?
Well, Your Honor, let me just elaborate on that point. One has to ask if it was that clear from the video where or why she fell. Do we need to have an engineer expert to tell us that? And an expert who does not appear to have any qualifications in analyzing video quality. When you think about it, Your Honor, let's look at what this expert said.
The video shows what it shows, and the clarity could be better, no question. But I suspect that there are experts with respect to the quality of film and how you can dissect it, where one might be able to have this film broken down frame by frame. That certainly was not possible for those of us looking at it now.
Yeah, well, that's my point, Your Honor, is that on a spoliation motion that the plaintiff made before the summary judgment motion, he made an argument that the plaintiff's counsel made an argument that the video just was essentially worthless because it lacked clarity. And on that motion, he had a expert in video, analyze the video. And the video said that the expert said that the video did lack sufficient clarity. And nowhere did that expert on video ever give an opinion that the video shows plaintiff's foot.
this is Judge Scarpula. That sounds exactly like you're talking about the weight of the evidence, not whether it's admissible, not whether it exists, but whether the jury should accept it or not. And that's exactly, you sound like you're giving your cross-examination of the expert, and that's fine. But we're not doing that on a motion for summary judgment.
Yeah, I understand your point, Your Honor. I just think that, there's got to be some degree, a reasonable degree of some clarity with this particular
counsel, this is Judge
video.
Scarpula again. You think that your expert who says that, oh, this woman got dizzy and fell is any more clear than a real video of what actually happened?
Well, Your Honor, if at the end of the day, we're saying that nobody has any clear evidence on why she fell, then the defendant should prevail on the case.
On
Mr.
that
Pagano,
note, I will let you come back on your rebuttal time.
Thank you, Your Honor.
Mr. Isaac, you have 5 minutes.
Thank you, Your Honor. Brian Isaac, I represent the plaintiff respondent, obviously. My position is kind of akin to what the court has been asking. These are jury questions, and on a trial, I have a different burden of proof than I do with respect to summary judgment motion. In a summary judgment motion, it's the defendant that has the burden of proving the case by negativing the plaintiff's claims in theory.
Mr. Isaac, this is Judge Singh. Would you agree that, I played the video a bunch of times. I don't know if she fell on step number 10. Is it that clear that she fell on step number 10? Or is it your position we shouldn't really go beyond what the expert says and allow the jury to consider it?
I think the latter. I think, to me, Mr. Bellizzi gave actual markers by which he categorized the steps. You could see in photos, as you know from reading the record, that he actually put little markers 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, and he graded them by the cylindrical or circular designs that were on the side. But the fact of the matter is you don't even have to go that far. The question is, if the defendant doesn't negate my claims, then that defendant's not entitled to summary judgment because this is a summary judgment motion and not a trial. I would also point out to the court, if I can, that this judge's decision was not altogether favorable to me. I probably lost 80% of the claims that I had. He ruled against me on Noseworthy. I think he was right on that. He ruled against me on the banisters. I think he was right on that too. He ruled against me on the stair dimensional claim. I'm not sure he was right about that. I think that's a cognizable theory. And if you look at page 28 and 29 of my brief, I have a very long footnote about the fact that you can consider that. But I think what he was concerned with was, if you look at 238 of the record and then the photo on 248, that's pretty clear. There is a precipitous drop with a 2-inch space off the edging that's crystal clear in the photo and crystal clear in Mr. Bellizzi's affidavit. And I think if you look at the cases, you probably have the lead case on this with causation, which is Hecker against New York City Housing Authority at 245 Appellate Division 2nd 131. That was a case where the plaintiff fell, left the premises, came back a day later and saw a defect and said you can infer that. That case was cited in Habibi, H-A-I-B-I, against 790 Riverside, and followed in a case called Rivera against 2732 Bainbridge, which involves almost the same facts as here. Last point I'll make, because I'm not going to overtalk. I know you have a long calendar. I'm not sure Dr. April's testimony is admissible. If I read your decision in Kaminer against John Hancock and Stewart against Transit Authority, both cited in the brief, speculation that someone who had a prior medical condition suffered a lesion on the day of the accident is not admissible. And I just want to tell you exactly what Dr. April said. This is on page 133. He says that plaintiffs, quote, may have suffered a seizure or a stroke that caused the fall in this matter. And then he goes on to say that his review of the medical conditions established that, quote, a potential cause for an intracerebral hemorrhage and acute stroke was those prior conditions. That sounds very, very speculative to me. Even if you don't agree with my theory, it's certainly insufficient, I would suggest, to establish prima facie entitlement to judgment as a matter of law. So based on that, we'd ask you to affirm the trial court's order. And I thank you for listening to me.
Thank you so much. Mr. Pagano, you have 2 minutes.
Thank you, Your Honor. Let me see if I could get this understandable, what I'm going to say. I reckon this back to that game at Yankee Stadium between the Yankees and the Orioles when someone hit a home run. I think it may have been Derek Jeter to right field, and they hit a ball to right field, and a fan reached out from the bleachers and put his hand over the fence and potentially interfered with the Baltimore Oriole outfielder who was going to catch the ball. Now, there was a video of that, and there's no question that the video showed where the fan's hand was, where the ball was, where the glove was, and it was up to the umpires to take that evidence, okay? The umpires, and in our case, it would be the jury. The umpires were the jury in that, and decide whether or not it was interference. But they did have a video with sufficient clarity, okay, to determine the facts that they needed, where the ball was, where the glove was, where the hand was. Here, Your Honors, we don't have anything like that in this case. So we're speculating on the facts because the video lacks sufficient clarity for a jury to make a reasonable, informed decision on the cause of this accident. Thank you, Your Honors.
Thank you so much. Levy versus Key Food. Mr. Kaufman,
Good morning,
you
Your Honor.
have 4 minutes.
Good morning, Your Honor.
Good morning.
As you know, I represent the defendants' appellants in this supermarket case. It's our contentions that the order of the court below by Justice Tapia should be reversed. Justice Tapia determined that inspections were not identified. I refer the court to pages 350 to 351 of the record, where Mr. Buckley, the store manager, testified under oath that he inspected the store on a daily basis in the morning, and he specifically walked up and down the aisles. It's our contention that this—
Is there an issue, Mr. Kaufman, that this display was sitting on top of a pallet that was protruding beyond the aisle? Is there an issue about that?
I can't say that that's the true issue in the case, Your Honor.
Counsel, that wasn't my question, whether you think it's the issue. My question was whether there was anything that controverted that was indeed the case on that day.
The plaintiffs testified that the items were sitting on a pallet and the pallet stuck out 2 to 2.5 inches.
And did your witnesses contradict that?
No, Your Honor.
Okay.
Not at all. And I'll tell you—
why isn't that enough to go to the jury?
Well, because, I mean, this is an item, this fixed stand of product that's maybe sitting on the pallet is a chest high.
Was it sitting on something else?
No.
Okay.
No.
So we've established that it was indeed sitting on this pallet that was protruding beyond the aisle.
Well, I can't say it was protruding past the aisle. It was in the aisle. And it was in the aisle. It was in the aisle where shoppers could pass by it with shopping carts. And it was chest high. And because of that, we believe it's similar to the clothing rack cases that this court has dismissed.
Except that this record describes this supermarket as being rather narrow in its aisles. And again, nothing in the record contradicts that.
Oh.
That is indeed the case. This is a very small store with narrow aisles. Correct?
I'm not sure having a narrow aisle is a defective condition.
No,
Obviously,
the aisle is not, that's not what I'm saying, sir. But if you take a narrow aisle and then you stick in it a protruding pallet, now you have a potential problem.
I beg to differ with what a protruding pallet is, Your Honor. This is a display, and I go to the supermarket every weekend, and I walk up and down the aisles, and there are displays in every aisle of the supermarket, and people have to walk past them, they have to walk around them, and it was no different. In fact, the plaintiff was in the aisle twice. He acknowledged standing next to the display with the pallet underneath, so he knew it was there.
Mr. Kaufman, this is Judge Shulman. Isn't there a reference in the record to the manager, Mr. Buckley, actually acknowledging that these displays had the potential for being a tripping hazard?
I didn't read the record that way, Your Honor.
I'm sorry?
I didn't read the record that way, Your Honor.
Well, my note is that Mr. Buckley kind of admission in what would be a cause and created scenario, that this pallet, as the Justice Presiding was discussing earlier was a potential for a tripping hazard on this record.
Yes, well, Your Honor, I don't see it as a tripping hazard. There's an accident, clearly. However, there were no other accidents involving displays or pallets in the supermarket before. Mr. Buckley testified he walked the store aisles every morning looking for issues. He didn't find any. The cases that were cited by the court below were all dealt with transient conditions in aisles, which involve water, grapes, packages being packed out at the time. This is a fixed object. And in fact, I'm looking at the bench behind each of your honors. It has beautiful molding that goes straight down to the floor, and then there's a lip around it, which also protrudes approximately 2 to 3 inches. And I wouldn't say that that was a tripping hazard.
Well, it's also not on the floor. So there's no way you can trip on it since it's at waist height. But thank you. You have time on rebuttal.
Thank you.
Mr. Steinberg.
Thank you. Good afternoon. It's Jason Steinberg from Burns and Harris. And I want to point out something, Judge Manzanet, that you had said is that given the fact that this is a narrow aisle, which is conceded by the defendants, together with clutter, customers walking back and forth, an elderly plaintiff, a protrusion of 2.5 inches sticking out from under display. When you factor in all those surrounding circumstances, it becomes an issue of fact for a jury as to whether or not that 2.5 inch protrusion was a open and obvious or a dangerous condition that was caused by the defendants. This is where the heart of the decision really is, as to whether or not Judge Tapia was incorrect. He held that it's an issue of fact as to whether that protrusion is a dangerous condition, and that is something that should go to the jury. As far as getting technical, it is their burden on summary judgment to eliminate all issues of fact, and they did not do that for multiple reasons. But even if we bypass all that, the heart of the issue really is whether that protrusion is dangerous, and that's something the jury needs to decide.
Counselor, this is Judge Singh. Your adversary has a different read of Mr. Buckley's testimony. Do you agree with them that Mr. Buckley didn't testify, that he did have concerns about tripping hazards?
The testimony is, and it's record page 385, and the question is, did you ever think that any of the displays in the store could cause someone to trip? That was always a consideration. That was his answer. That was always a consideration. So that's knowledge that these displays have the potential to be a trip hazard in and of itself. Now factor a 2.5 inch protrusion into the aisle with all the other surrounding circumstances. Clearly you have issues that a jury needs to resolve, and they should be able to take into consideration, the manager's testimony in that regard as but one factor. As far as technicality, they didn't demonstrate in their motion that this is not a dangerous condition. They didn't affirmatively demonstrate or eliminate all issues of fact in that regard. Obviously, they're the ones.
How do you address Mr. Kaufman's argument that your client passed this particular spot several times prior to his fall?
Okay, my client didn't notice or see the 2.5 inch protrusion. That's not something that's readily observable by the use of one sentence, and Judge Tapia recognized that. He says in his order, given the circumstances, could this be a trap for the unwary? In other words, here's Mr. Levy, an elderly gentleman who is faced with a narrow aisle that's further narrowed by the fact that there's a display where only one customer at a time can pass by. He has to let these people pass by and then step around the display. In doing so, his foot catches the 2.5 inch protrusion. So the fact that he passed by the display itself a couple of times doesn't necessarily mean he saw the 2.5 inch protrusion. So that would be unfair to hold that it was that open and obvious. As far as, and also this is technically a transient condition because this isn't a permanent fixture in the supermarket. So when you have a transient condition, you have to demonstrate your burden as the defendant trying to get a case dismissed that you have to demonstrate when you last inspected the aisle. Somebody would have to testify. I saw the display. There's no 2.5 inch protrusion there. That didn't exist. We determined it was safe. You have that kind of evidence in a summary judgment motion. Maybe it's successful, but that didn't happen here. So we have to go to the jury and they have to listen to the testimony and see the evidence in the case.
Thank you so much.
Thank
Mr. Kaufman, you have 2 minutes.
I'll just respond to two things. Number one, there was no testimony or evidence of, quote, clutter in the aisle where the plaintiff fell. Number two, when Mr. Buckley was asked in response to Justice Singh's question if he thought that the displays were an issue, he said it's a consideration. Well, he's the manager. He walks the store looking for things. So yes, he considered it. Did he find it to be a tripping hazard? Apparently not. And nobody else did, because he was also asked if there were any other tripping accidents in the supermarket, and there hadn't been. So it's our contentions it was an open and obvious condition, and there was nothing defective about it.
Thank you so much. You have a good day.
You too.
Albuquerque versus City of New York. Mr. Tachich. I hope I said that right.
Close.
Say again.
I'm sorry, my phone kept auto-muting. Tadich, on behalf of
Tadich.
defendant.
Okay. My apologies again, and you have 6 minutes.
Thank you, Your Honor. Good morning, Your Honors, and may it please the court. In the context of Labor Law 240 sub 1, where a plaintiff is injured by a falling object, which is neither being secured nor hoisted at the time that it falls, which is undisputed in this matter, liability will only lie if the object required securing for the purpose of the undertaking. Now, when grappling with this issue, New York courts have distinguished between those cases in which an object falls because of the absence or inadequacy of a safety device, and those cases where the object is deliberately dropped, often into a designated drop zone, as part of an understood protocol used to achieve the end goal of the work. Now,
well, typically on those latter cases, we're talking about where debris is generally thrown to during construction. It's not the type of thing that you typically do as a part of your work.
I would say
throw out garbage. So those cases that you're referring to of deliberately throwing down items, that's typically garbage and debris, is it not?
The answer to that is yes. Most of the cases, it has been not just garbage, it would be debris or demolition. There is precedent for cases where it's not garbage, and that would be Galvin v. Triborough, which is a second department case from 2018. But also, none of those cases turned on that fact. It was never a dispositive inquiry that the court made. And in the context of labor law, it doesn't really make a lot of sense when the statute covers demolition workers. It covers those laborers who are removing debris from a construction site.
Right, but that wasn't this case. So why don't we deal with what this case is about? Because as I understand it, the pieces of timber that were being thrown into the pit were not debris. They were items being used to shimmy the very work being undertaken in the pit.
That's correct. And they were
so that's different from the cases that we have, no?
I would say that it is different, but in each of those cases, starting with the Court of Appeals in Roberts v. GE, and in this court's own precedent, Torres v. Lovelane, Vega v. Metropolitan, and Solano v. City of New York, in none of those cases did the court state that debris may be deliberately dropped, whereas something that's installed may not. And I think some of the flaws in this reasoning were on display in plaintiff's opposition, particularly when they discussed the Hari Naren case, which comes from the second department. And
well, I mean, here what I find peculiar is that it was the supervisor who sent him into the pipe. It was the supervisor who allowed the throwing of the timber into the pit after having put him in the pipe and not having accounted for this gentleman's whereabouts before allowing that procedure to continue. So why is this not an appropriate 240 sub 1 case under those facts?
Because the deliberate dropping here was into a designated zone, which, as acknowledged by plaintiff and by his brother-in-law, was not only uniformly performed in the past, but it was understood that this was the protocol and that this
Counsel, we have a lot of cases in the labor law area where things are done routinely. That doesn't make it right. And that doesn't make it within the ambit of the labor law.
You're correct, Your Honor, and I'm not making an argument about custom. I'm talking about what the precedent from this court and every other department has held in a deliberate dropping case, particularly where there's a designated drop zone. And so I think if we're talking about—
Well, this wasn't really a designated drop zone because the zone kept moving as the work progressed. As the pipe was laid and tied together, that zone that you keep on referring to kept moving. So this is not at all like any of those cases that you're referring to, not by a long shot. You have a moving target in this hole.
It was not an arbitrary location, though. It was one that was specifically chosen by the workers down in the pit. And it was, in fact, the testimony actually established that it was at a minimum of 5 and a maximum of 10 feet away from that pipe. And furthermore, the protocol actually called for the workers to declare that they were going to be dropping something into that location, looking, and once it was cleared, making that drop. In this way, it's very much similar to the Vega v. Metropolitan case where the plaintiff actually entered a zone and materials were dropped and they—
Except that here, the plaintiff was placed in the zone by his supervisor. You seem to be ignoring that fact.
Your Honor, I would actually disagree with that specific characterization because—
Was he not sent into the pipe to check the pipe?
The material was not
inside the tunnel.
He was sent inside of the pipe to the tunnel, but that is not where the accident occurred. The accident—
Of course not. But they didn't wait for him to get out and clear the pipe before they kept on throwing timber.
Your Honor, he exited the pipe and walked between 5 and 10 feet directly into the zone where they were dropping the timber. And as he explained in his affidavit, 8 days after the accident, he knew, and there was no confusion, that that was what was happening and that was where the materials were dropped.
Right.
Counselor,
The affidavit that was
Judge Singh,
prepared for him. Go ahead, Mr.
Judge
Singh.
how do you distinguish cases like Diaz, where plywood was being dropped, and what we held there was that was the kind of load that should have been secured? Isn't this essentially similar to Diaz?
Your Honor, I think that this case is very different from Diaz because in Diaz, the exact protocol required the plaintiff to be working underneath where this was happening. It wasn't they're removing these forms and they're falling into one specific zone. They were removing forms from the concrete and plaintiff was positioned directly below the forms.
But what we say there is the type of work being performed, dislodging heavy plywood forms from a newly construction concrete ceiling, involved a load that required securing. Couldn't you make that same argument here that this timber, heavy timber being dropped, should have been secured going down into the pit?
Your Honor, in every case that's been cited by either plaintiff or in our briefs, you could have a feasibility argument that in Roberts v. GE, they could have attached the asbestos to a sling or to a rope, and then that would have prevented the accident. The same thing with Solano, Vega, and Torres. Where I see Diaz as being substantially different is that they didn't have an established protocol of dropping into a zone that's cleared of workers. In fact, it was quite the opposite. The workers were directly below where this work was occurring. So therefore, using the test of falling objects.
But that's exactly what happened here. Plaintiff was below working. He was told by his supervisor to go make sure, I think, that the pipe was properly connected. Right. I don't see any difference between this case and what you're arguing.
You'll have time on rebuttal.
Thank you, Your Honor.
Okay, Mr. Isaacs, you have 5 minutes. Please unmute yourself.
Can you hear me now?
Yes.
Okay, I'm sorry. I'm very strict.
Okay.
Brian Isaac, I represent the plaintiff respondent. I just want to push back and I want to discuss Diaz also. As you know from reading Diaz, Diaz is actually my case. and I have some things to tell you about it that I think you're going to find interesting based on the actual record. But there are constant references to there being a controlled access zone here. Okay, I don't think there's any controlled access zone here. Justice Manzanet, you asked whether or not the plaintiff was directed to go in and work in the pipe. The answer to that is yes. 388 of the record, unequivocal, no question about it. This isn't a case where they're dropping debris and they're moving debris. This is a case where they're throwing materials that they're using to stabilize the water mains in. They're actually using the materials, not discarding the materials. And
this is Judge Scarpula, but just tell me, why do you not think this is a drop zone? It's a zone, right? There's the formula saying I'm going to drop this stuff in. And when I say all clear, why is that not a drop zone?
Because Mr. Caleo's testimony, or I think I spent it, I'm just going to call it Caleo, that's how I think you pronounce it, doesn't establish that. And let me give you the pages, Justice Scarpula, if I can. 418 of the record, this is how he described it, and I'm quoting it word for word. All of us asked, what's the best way to take this down? We're going to cut them, everybody clear out of the way, the guys look down and throw them down in the hole. Then on page 507, he was asked what he meant by the term controlled manner. And this is what he said. It's a direct quote. Tell them, make sure you look both ways, the guys on the top, and yell, heads up, the timbers are going down. That's not me making that up. That's the defendant's star witness. That's not a controlled access zone, nor is it a drop zone. That is a generic procedure saying, hey, we're going to throw something, don't be down there. But that's completely different from controlled access zone cases. And I would point out that Roberts against GE has been sensibly attributed by the appellate divisions to deal with situations where you're dealing with essentially demolition, removal, and debris. And I think the courts are right. If you look at 240 sub 1 of the labor law, it doesn't mandate a particular methodology or a particular means that you have to use when engaging in demolition removal. It doesn't say you have to use a cat machine. It doesn't say you have to use a hoist. It doesn't say you have to use a pullover machine. It doesn't say you have to use a rope or a chain. And so the courts have said, look, we're not going to force defendants to do things a certain way, but certainly this is an elevation-related risk on the runner. And with respect to Diaz, not only is it on point, Diaz was a worse case. Because in Diaz, the plaintiff was actually, the work was actually demolition work. It wasn't the work that they were doing. It was the stripping of plywood forms. I also want to point out one other thing, and then I'll stop talking. If you look at Carol Finocchio's brief, that was my adversary in that case. On page 31, this is what on page 30 of her brief, she writes, and I'm quoting, he, meaning the plaintiff, testified that his coworkers had been deliberately tossing used plywood onto the floor, and that he was injured when his coworkers, quote, let go of the plywood, referring to page 368 of the Diaz record. On the next page, the very next page, she writes, quote, if, as plaintiff testified, the plywood was either intentionally thrown or intentionally dropped by his coworker, section 240 sub 1 does not apply. And if you look from 31 to 32 of her brief, I swear it is almost exactly the same case citations, not only by citation, but by temporal time limit that you see in my adversary's brief. So I would suggest to you that the trial court got this one absolutely right. In fact, they called defendant's position absurd. And we need to remember that this is a labor law 240 case. It's not a negligence case. I think it would be a good negligence case anyway, leaving aside the fact workers' comp would be a defense. But I don't see any basis for applying the Roberts line of cases. And I would also note that not only in Diaz, but in the Mora case, you did not apply an absolute standard where something is done intentionally or purposefully. Labor law 240 sub 1 doesn't apply. So we would ask you to affirm. And if you have no questions, I'll rest on my brief. Thank you for listening to me.
Thank you so much. You have 2 minutes.
Yes, Your Honor. I want to address a few things that my esteemed colleague, Mr. Isaac, brought up. First, this protocol was not a haphazard. I know he read from the record just a very limited self-serving excerpt. It was not a haphazard protocol. You can look at the record, pages 600 to 624, where you can see the numerous affidavits, including one from plaintiff himself, talking about the established protocol that was discussed every Tuesday at the safety meeting, where it was understood by all workers that they do not walk underneath the two workers who are standing up on street level before they drop the timber into the drop zone. Now, Justice brought up the fact of a drop zone. How is this not a drop zone? I believe that this is a straight application of the law where we're talking about a deliberate drop where it would not be even understood or necessary or expected that safety devices would be used because workers are not supposed to be in that area. To the extent that the judge believes that this may or may not have been an adequate drop zone, I would say in the first instance that the adequacy of the drop zone isn't necessarily a question for 240, but if it is, that inherently is a question of fact, which the court completely overlooked, the lower court that is, when they started from the position, as Mr. Isaac acknowledged, that our position was absurd. But I do believe that under a straight application of the law, we have a deliberate drop into a zone which is known and understood to be a drop zone. And for that reason, nobody expected, and it wasn't necessary to use devices to lower that object. And therefore, under the labor law and the jurisprudence of this court, the Court of Appeals, and every other department, it cannot be said that the object fell because of the inadequacy or absence of a safety device.
Thank you so much.
Thank you, Your Honor.
Have a good day. Agley versus PS Contracting. Mr. Murphy.
Yes, good morning,
Have
Your
4
Honors.
minutes.
Good morning, Your Honors. May it please the court. James Murphy for the plaintiff's appellants. The lower court in this action denied the class certification motion for the sole purpose, for the sole reason that they felt that the numerosity prong of CPLR 901 had not been met. There was absolutely no basis for that determination. The only evidence in the record before the court as to the size of the class was the affidavits of 7 individuals, named plaintiffs and putative class members, who testified that they worked with at least 40 other employees of PS Contracting.
Oh, counsel, this is Judge Scarpula. That's not even right. The defendant put in payroll records that showed something completely different, and your clients simply said, we saw, I mean, those affidavits could not have been less helpful if they tried. We saw at least 40 people on every site every day. That, I don't know how you could say that that met your burden.
So the payroll records that were submitted by the defendants in opposition were not in any way complete payroll records that reflected the actual number of workers that perform work on these projects. They were a very limited sampling that contained only the names of the individual named plaintiffs and redacted all other information. These type of affidavits with workers talking about, I worked with this X number of other workers on these projects when I was underpaid by this contractor, have been upheld by this court to...
No, not just that. Not just affidavits. Affidavits plus payroll records. If at the cases that you are talking about, it was never simply a generic affidavit that met the burden.
In the case of Galdamez versus Biordi Construction, which was I believe a 2008 case from this court, the only evidence as to the numerosity were affidavits from individuals who said that they had worked with between 30 and 50 other people who were employed by Biordi on public works projects. This court held that that was sufficient to establish numerosity. Similarly, in Stecco versus RLI, there were affidavits from workers who said that they worked with at least 50 other people on these projects, and that information was found to be sufficient to uphold the plaintiff's burden for numerosity. The defendants here refused to engage in any discovery whatsoever until Judge Billings denied their motion to dismiss in November of 2017, and thereafter refused to provide any discovery other than...
Mr. Murphy, this is Judge Singh. All of us have spent time in the trial court, and, you clearly had remedies. You can't just sit on your hands and then jump up and down and say they didn't provide records. Why didn't you, and over the last 3 years, do what you needed to do to get the records?
Well, because this court has repeatedly held that these types of affidavits are sufficient to establish numerosity. In Dabrowski versus AVAX, as I said, in Galdamez versus Biordi, that was the only evidence to establish numerosity was affidavits essentially identical to these in Stecco versus
No, counsel, let me interrupt you for a second. This is Judge Scarpula. In that case, they named specific people. The affidavits had specific people who work with the plaintiff. Here, these plaintiffs just said 40 guys who I don't know. That is a completely different affidavit. And Pizzaites, I guess, it's payroll records plus affidavits. It's never just, none of the cases you cited is just a generic 40 people who I don't know their names, I don't know anything about them, but they were all there. That clearly has never been, or I would like you to point me a case where that was the only thing that was said, because I certainly didn't find one.
Well, you know, as I said, that whether the other individuals are identified by first name or by full name or nickname in some instances, in cases like this where these affidavits are submitted, that the core allegation that is sworn to under oath by these individuals is that at least 40 people were working on these projects. The affidavit,
and then defendant puts in records, payroll records that say, no, that's not true.
The defendants didn't allege that those were complete payroll records. The defendants never said that.
You'll have time on rebuttal. We've gone through this question twice now. Okay, Ms. Deeth for respondent technical. You have 5 minutes. Ms. Deeth, we cannot hear you if you are trying to speak.
Apologies, Your Honor.
No problem.
Good morning, and may it please the court. The trial court properly denied plaintiffs' motions for class certification, correctly holding that plaintiffs failed to satisfy the numerosity requirement of CPLR 901 and 902. It's respectfully submitted that the court should affirm the orders of the trial court denying class certification. I will address both the findings of the trial court below, which should not be disturbed, and the fact that
the states, this is Judge Singh. I would like you to address my concern, and my concern is that you did not provide complete payroll records. You cherry-picked records, and you provided what you wanted to provide. Why didn't you give the plaintiffs a full set of the records so that they could make their motion, or a stronger motion?
Your Honor, the records that were provided, I've been told from my office, were the records that they had, and that they did turn over.
That's not adequate. Ms. Deeth, that is not adequate. Having run a discovery part, when you are ordered to provide a certain set of records, it's not, oh, this is what I have on hand. It's you make sure that your client retrieves the records that have been ordered by the court. So why should you benefit from your client's failure to abide by a court order?
Okay, well, with all due respect, Your Honor, we thought that this was resolved in the trial court below, and plaintiffs were given an additional 3 years to try and come up with a case. We provided records.
Counsel, your clients refused to continue with discovery during the pending of motions. Again, the record is replete with game playing when it came to the discovery process. Again, why should your client benefit from that game playing?
I'm not asking my client should benefit from the game playing, Your Honor. Basically, as I said, the records that the client had, the client did turn over. And this was a very large job site. I mean, we were not the only trades on site there. This was a massive project where there could be 10 or 15 different trades on it the same day. So for the plaintiffs to say that they work with 40 other people, there's no way to ascertain who those 40 other people are or who they worked for.
And isn't that the reason why we need the records? All the payroll records, for the length of the project to make those kinds of determinations.
Yes, Your Honor, I certainly understand what you're saying. And again, we did provide what we had, but they couldn't even name a single person other than
Counsel, that's not unusual. Counsel, on construction sites, there are dozens sometimes of labor laborers who are not part of the normal payroll and not a part of the construction company's typical team, but they are nonetheless human bodies that are there working. Okay, and who is in the best position to provide those records? Certainly not the workers. Okay, so let's stop pretending that a typical construction worker has the capacity of providing payroll records that they have no control over.
Oh, I wasn't trying to infer that the defendant would be able to have the payroll records. What I was saying is that on a job site, if they're working with these people day in and day out, they should be able to have more than just 6 people they've come up with in 3 years' time.
Counsel, this is Judge Scarpula, but just doesn't it seem like the payroll records are going to make this clear one way or another? And why are we all sitting here? Why not just give the payroll records? And we can tell whether or not there's 7, as you say, or 40, as the plaintiff says. I mean, there's a simple solution to this.
I agreed, Your Honor. It's my understanding that we did turn over the payroll records that we had.
I looked at those records. If that's all you have, then you're not complying with your obligations as a New York State corporation. So I wouldn't be saying that if I were you, because those records definitely don't comply with your obligations.
All right. Thank you, Ms. Deeth. You're out of time. Mr. Sue, you have 3 minutes.
Yes, may I please the court? And this is Eric Sue from Cool Mooring, and I represent Zoria Housing, a respondent in this appeal. And I want to answer the court's question regarding how plaintiffs or appellants could possibly have gotten information besides the sampling of payroll records that were provided to, that were part of the production to
Did the court request, I'm sorry, Mr. Sue, did the court request a sampling of payroll records or the providing of all payroll records?
Attached to,
That's provided. A simple question. Either the court asked for.
We did not provide just a sampling of payroll records. We provided.
I'm sorry?
We did not provide just a sampling of payroll records. It was a sampling of payroll records that were attached to the opposition papers, were there for purposes of demonstrating several very important elements. One being Mr. Demetrius, who was a supervisor and found to be a supervisor by the trial court, who had access, who had control, who also distributed paychecks, as he attested in his affidavit submitted in support of plaintiff's motion for class certification. He could not provide any more detailed information than the 40 plus individuals that he attested to be working with that were basically the same boilerplate information as the rest of the affiants. And Your Honor, this is the person, more than any person on the job site, who could attest to how many people actually worked alongside him. And he could not provide information more specific than that. I would submit to the court that is an example why the trial court properly found that plaintiffs failed to satisfy their burden of proof in order to overcome and comply with the necessary showing for numerosity. This is that very best person with the very best information who's certified, by the way.
Counsel, this is Judge Scarpula. Isn't the employer the very best person with the very best information, with records that are required to be kept by both the federal and the state government as to how many people they employ? And so again, I just don't understand. Why don't we just put those records together and finish this? Because that's going to be conclusive one way or the other, unless the plaintiffs have something else.
And the records have been provided to plaintiffs, 1, and 2, Your Honor. Your Honor, I think it's important to note.
If that's
point out the right,
let me counsel. This is Judge Scarpula. If your redacted sampling is what you're saying was what was produced, I don't think that's true.
Your Honor, during the process of discovery, To the extent that objections were made regarding the production and then subsequently additional information required to be provided, we were not the plaintiff in this case. We're not the one who should be driving litigation. And secondly, Your Honor, I want to point out something that
I don't even understand that statement. It's not a question of you having to drive the litigation. It's a question of you having to abide by court orders to provide discovery that clearly have not been provided in full. But we are out of time. Thank you so much for your argument.
Thank you, Your Honor.
People v. David Gant. Ms. Myers, you have 5
Yes,
minutes.
hello. Good morning. Can everyone hear me okay?
Yes.
Great. Good morning. Katrina Myers from the Office of the Appellate Defender for David Gant. The court should exercise its interest of justice powers by reducing Mr. Gant's 12-year sentences to 2 10-year concurrent terms. Mr. Gant had a psychiatric break and was intoxicated when he committed the underlying offenses. Specifically, he was suffering from hallucinations and was high on PCP when he robbed Mr. Mustafa. When officers began to pursue him, Mr. Gant ran to the back of his mother's apartment building, where a YouTube video shows him attempting to commit suicide by pressing a gun against his temple and pulling the trigger 3 times. After he was subdued, officers brought Mr. Gant to the hospital with active hallucinations. Doctors found him dazed and crying on a stretcher, expressing that he didn't want to live. Mr. Gant later tested positive for cocaine, marijuana, and PCP. In fact, Mr. Gant was poisoned by PCP on the day of the offense, as he was treated for a condition called rhabdomyolysis, which is a breakdown of muscle tissue caused by PCP intoxication. When Mr. Gant was able to speak with doctors, he indicated that he was also suffering from auditory hallucinations since he was a child. These circumstances diminish Mr. Gant's culpability and make a 10-year sentence more than sufficient to achieve the sentencing goals of furthering his rehabilitation, protecting the public safety, and promoting his successful reentry. I think it should be noted that Mr. Gant first became aware of a diagnosis of some sort in 2013 when he was 27 years old. This was 1 year before the instant offenses in this case. During that time, he was prescribed medication, but as with many serious psychiatric issues, it's a process to be able to find the correct medication for the body to acclimate to it, and to also find a therapist who can properly treat and address the issues that Mr. Gant was facing as a young man who grew up in a violent community, who had suffered from a serious case of domestic violence, and quite frankly, needed all of the help he could get. Mr. Gant was able to come to a realization after this arrest that his behavior on the day of the offense was absolutely unacceptable. He expressed remorse and is grateful that no one was hurt on that day. And he has started to take medication and seek active treatment. As soon as he went to Rikers, he began to see a psychiatrist and take medication. He is working hard to make sure that this issue never happens again. Because this was a complete psychiatric break, the court should use its interest of justice jurisdiction to reduce his sentence to the minimum. The minimum sentence already accounts for the heinous nature of these crimes, as well as Mr. Gant's prior criminal history, which were again tied to his exposure to community violence and his domestic violence history, and yes, living with a history of untreated auditory hallucinations.
Thank you so much. You'll have
Thank
time
you.
for rebuttal. Mr. I know I'm not going to pronounce it properly, so could you help me?
Yes. Commendoria.
Commendoria. Good morning. You have 5 minutes.
Thank you, Your Honor. Good morning, and may it please the court, John Commendoria for the office of Darcel D. Clark. I should take you to the garbage heap and shoot you. These were the words that defendant, a second violent felony offender, used to rob Mr. Mustafa before later taking aim at police officers trying to apprehend him and pulling the trigger 3 times. His lenient sentence to 2 concurrent 12-year terms of imprisonment with 5 years post-release supervision should be affirmed. Initially, the totality of the circumstances showed that defendant validly waived his right to appeal. Defendant on the record, after having pled guilty twice to robbery 2, affirmed that he understood both the court's colloquy and the detailed written waiver that he executed with counsel. Furthermore, the oral colloquy occurred after the trial rights were explained that were automatically forfeited by pleading guilty and after he allocated to the facts. As to the excessiveness of the sentence, the facts in this case do not warrant a sentence reduction. Not only did he take a loaded gun, cock it, put it back in his belt, and then threaten to shoot the victim before robbing him, he later turned that gun on police officers, knowing it was loaded, and pulled the trigger. Only when it did not discharge did he scale down an 8-foot wall and break his ankle before being apprehended by police. I would like to correct something within the people's brief. Defendant's sentencing exposure for the attempted murder of a police officer was 40 years to life, not 25 years to life. And regardless, he pled guilty to attempted murder too. That carried with it a possible sentence of 25 years. Because the robbery and the attempted murder were separate acts, those both carrying a possible sentence of 25 years could have been consecutive. Instead, defendant worked with the prosecutors and his attorney to reduce the sentence to 12 years concurrent, just 2 years above the minimum. The only complaint he has is that it's not the most lenient sentence. In fact, everybody, the court, the prosecutor, and the defense all knew that this was going on because a year before he accepted this plea agreement, he said in his 390 hearing, and I quote, they offered me 22 years. I am not taking that. I'm trying to get this offer knocked down to something more reasonable. So it was then reduced to 20 years and then 15 years. And finally, it was reduced to 12 years where he accepted it. And it wasn't 12 years consecutive, it was 12 years concurrent.
Thank you.
Thank you, Your Honor.
Okay. Ms. Myers, you have 2 minutes.
Thank you, Your Honors. To turn to the validity of the appeal waiver first. The totality of the circumstances surrounding the appeal waiver must reveal that it was knowing, intelligent, and voluntary. And where a court mischaracterizes the utter nature of the appeal and what the waiver means, it cannot be said that a defendant knowingly waived his or her rights. In Mr. Gant's case, the court told Mr. Gant that by waiving his rights to appeal, he could not bring any issues before the court for review. This was overbroad and not bolstered by any other statement on the record to correctly inform Mr. Grant about the waiver and its import. And in fact, this is the only statement the court made on the record and was incorrect. So the record is pretty barren in terms of an oral colloquy as to the existence of the appeal. To turn to Mr. Comandoria's points about an excessiveness claim, yes, Mr. Gant did negotiate for a lesser sentence, as anyone who would be facing a criminal conviction would. However, the statute
Ms. Myers,
does...
this is interesting.
Yes.
Isn't that an important fact here? That in fact, this was a negotiated sentence between the prosecution, defense counsel, and the defendant, and it's really 2 years above the minimum. I'm not, which is a lot of time. I agree. But how should we consider the fact that this was a negotiated sentence that was arrived at and was pretty favorable to your client?
Right. Yes, and it's understandable that this was a negotiated sentence and the court did consider the factors. However, I think it's important for this court to look at those factors again and the circumstances surrounding his or Mr. Gant's arrest. Now that time has passed, now that it's 6 years since the offense and he has been serving time, and see and recognize that his suicidality, his hallucinations, and his PCP intoxication did diminish his culpability. He was not in the right mind when he committed those crimes, and as indicated in his record, he shows great potential to not commit those crimes again if he is under proper mental health treatment. And unfortunately, because of his socioeconomic class and his background, he never had the opportunity to receive that treatment before.
Thank you so much. Have a good day.
Thank you, Judge. You too.
Eagle Hill, Gen Par versus FPCG. Appellant, Ms. Cohen, you have 5 minutes.
Thank you, Your Honor. I represent FPCG, the defendant and appellant here, and we are seeking to have the lower court's decision reversed on a motion to dismiss a breach of contract claim. I want to address 2 points here with you today. The first being that Eagle Hill has been arguing that FPCG is attempting to rewrite the contract and removing its right to a clawback provision. The language that Eagle Hill uses in its brief is important to note and to look at, I think. On page 9, they refer to their right to a divestment as well as a reduction. The sentence reads, the reduction clause expressly makes the placement fee subject to reduction or divestment in the event of a reduction in the funds. Divestment, that word doesn't exist anywhere in the contract. And Merriam-Webster defines divestment in a few ways, but the 2 most applicable here are to deprive or dispossess.
Counsel, this is Judge Singh. Why don't you focus on the issues at hand, and that's the reduction clause, and why you believe it, why you're entitled to keep the monies.
Well, because the reduction clause is essentially that. It is a reduction clause. It is not a divestment.
So I'm asking you to focus on the reduction clause. Why do you believe you're entitled to keep the funds? Wasn't there, just based on the record at least, an accommodation made through an email exchange where at first Eagle Hill wanted to save interest and wanted to prepay, and then subsequently I don't remember who it is from maybe it was your CFO, wrote to Eagle Hill asking again for sort of custom and practice of continuing that prepayment because one of the principals was going to have a baby soon.
That's correct. But
so are you saying there's a modification of the contract? I mean, what's driving this?
Well, Your Honor, I think that there are 2 ways to look at this. First of all, on its face, the reduction clause is simply that. It applies to future installments. It does not apply to payments that had already previously been made.
When do these installments come due?
They came due.
Forget about when they were paid. When do they come due under the agreement?
Under the terms of the agreement, they were due. There was a schedule for payment, and they became due in 8 equal quarterly installments. They shall be payable in 8 equal quarterly installments.
When?
Following payment by the funds. There was the payment schedule was worked out based upon the fact that Eagle Hill was going to pay in installments and pay interest on those payments. When Eagle Hill paid the Guggenheim payment before it was due, as requested by FPCG, that installment was no longer payable and due. It cannot be a future installment when it's no longer due and payable. I think that it seems illogical.
Judge Scarpula, you have to unmute your mic.
You asked for an accommodation, and that's why it was prepaid. And so now you're saying, thanks for the accommodation for the prepayment, but you're not entitled to take the benefit of your contract, which says that you're entitled to the reduction on the You can't have both. clearly that would, I mean, clearly you can't have both. You're saying we got the benefit because you did us a solid and prepaid and didn't wait for the quarterly payments. But even though there is an entitlement to a reduction, if you had done that, you're not entitled to it. Isn't that exactly what you're saying?
No, Your Honor. They got out of having to pay the interest by paying that portion up front or early, prepaid. That's the deal there. The benefit of their bargain was they no longer have to owe us interest. What they want now,
except that the writing required any such modification to be writing and signed by the parties, and it wasn't here. But you're out of time. You will have time on rebuttal to address this issue.
Thank you.
Mr. Hagan?
Good morning, Your Honors. May it please the court.
You have 5 minutes.
Thank you, Your Honors. The only commercially reasonable and fair way to read this agreement is that the right to reduction was not extinguished because Eagle Hill voluntarily paid the amount early expressly as a favor due to the impending birth of one of the principles of focus.
Well, counsel, that's not exactly accurate. You initiated because you didn't want to pay interest, and which is fair enough. So it was an accommodation to both sides with respect to the email exchange. Isn't that accurate?
Well, with respect, Your Honor, my clients had inquired months earlier, I believe in August 2017, isn't this the deal? If we pay early, don't we not have to pay interest? And that was acknowledged. And then it was months later in December.
And you made
I'm sorry?
And you made a prepayment at that point, no?
We may have, but I'm not sure that was with respect to the same payments that are at issue here, because these were quarterly installments.
I understand. But the point being is that payment was made, and that was an accommodation to you because you didn't have to pay interest. And in December, it was an accommodation to the other side because of the impending birth, I guess, of a child.
That's fair. Of course, absolutely, Your Honor. The document specifically acknowledges in the portion addressing interest that the interest is accruing daily. Therefore, if you prepay earlier, then you're not accruing that daily interest. And that's the case. But that doesn't negate the fact that if you do prepay earlier and those subsequent events that occur reducing your fee automatically trigger the reduction clause. If Focus Point wanted to make it such that the reduction clause no longer applied in the event of a prepayment, they could have easily used different words. They could have conditioned the reduction clause to be extinguished in the event of, or only apply in the event of outstanding payments. They could have said it applies unless it's already been paid. And the agreement uses these different terms in different contexts. So in Section 4F, the payment is not due or payable until the end of the quarter in those 8 equal installments. That was not necessarily, I mean, it was an accommodation in the sense that, of course, interest is accruing daily, and if you prepay, just like your mortgage payment. Your mortgage payment is due on a particular month, and you're accruing interest even if not because you make the late payment, just because the mortgage does not mature until 15 or 20 or 30 years down the road. So you're incurring that interest even though you're paying timely and according to the schedule that you agreed with the mortgage company. And another, sort of similarity here is that this happens all the time in the context of employment agreements. You have an employment agreement that entitles an employee to a commission, and even if it's earned when the sale is made, it's not payable until the revenue comes in. And if the employer does the employee a favor and says, I'll pay this to you in advance, it's not fair or right or reasonable that if the revenue doesn't come in or it's not reduced, that somehow the employer has waived the right.
I'm sorry, go ahead.
I was just going to say that the quid pro quo in that case is you get forgiven the interest, but the other side gets the use of the money. And maybe they could make it make more money on that money for that period of time. And so that's a commercially reasonable exchange.
Yes, Your Honor. And in this case, we were penalized because Eagle Hill's agreements with respect to the funds that it was managing was that if something happened such that the investors withdrew their funds, then Eagle Hill no longer received its fee. And that's exactly what's alleged to have happened. In this case, alleged in our agreement that the funds were terminated, the fund closed, and therefore Eagle Hill's management fees were reduced. And that's exactly what is recognized and called for in Section 4F, a dollar for dollar reduction in the funds or the fee that would be attributable to Focus Point.
Thank you so much. You're out of time.
Thank you.
Okay. Ms. Cohen, you have 2 minutes. Please unmute your mic.
Sorry, Justice
No
Singh, I wanted to address your question about the prepayments previously. And yes, that happened twice. Eagle Hill chose, and the email correspondence reflect that the parties modified the contract insofar it says.
Okay, let me just stop there for a second. I think it's been pointed out already. I mean, there's a very specific provision of how the contract can be modified. And we're dealing with the motion to dismiss. So the question is does the documentary evidence utterly refute the plaintiff's claims? How can you say that on this record that it does? Maybe you have an argument for modification through a fully developed record, but in this instance, the contract controls, it seems to me, and you didn't follow the provision with respect to how to modify the contract.
Well, Your Honor, we believe that the email correspondence does establish a modification, and that goes back to the August 21st communications, which are in the record.
Except, counsel, that while this court has certainly has cases that say that a contract can be put together from emails between parties, but we have never said that that is the case where a contract says any modification must be reduced to a writing signed by the parties. And to me, at least, speaking for myself, that is the hump that I don't see how you get over.
Well, Your Honor, the cases say that a modification can be reduced to writing and signed by the parties, and an email signature sent to the other party is sufficient for a written modification. I think that these emails clearly establish.
Can we say that conclusively on this record, that it conclusively establishes the party's intent to modify the contract? I mean, this is on a motion to dismiss.
Yes, Your Honor. It's our position that, yes, it does conclusively show.
Fair enough.
Okay. Thank you so much. You have a good day.
Thank you. You as well.
CAS Marketing and Licensing versus J. Franco and Sons. Mr. Ruskin for the appellant. You have 5 minutes.
Thank you, Your Honor. And it's a pleasure to be before you virtually, although I must say I miss being able to look up at the ceiling and seeing the name Proskauer. But hopefully we'll all be together in person soon. Your Honors, there are multiple fatal errors in the decision below. The court found an implied in fact contract as a matter of law. That's an extraordinary and frankly virtually unprecedented result on summary judgment, and found that Franco was obligated to pay damages to CAS, implying facts and making inferences on a series of issues that are hotly contested, including whether a contract was formed and including notably, if it was formed, what its terms were. And I want to focus particularly today on certain terms where there are clear issues of fact, whether or not performance was required by plaintiff, number one, what the duration or term of the agreement was, number two, and when payments were allegedly due, if they were due at all under any contract. As to each of those which are necessary for the summary judgment below, as to each of those, there are hotly contested facts. Now, admittedly, there are some bad facts in the record, or some problematic facts, and the judge focused on those facts. They include certain deposition testimony, they include a stipulation, and they include a request for certain admissions. And plaintiff will be able to argue from those facts the inferences that should be drawn. But those are arguments that it should make or can make to a jury. None of them eliminate the factual disputes between the parties. Several things that I can point to. First, I point to the affidavit of the president of the company, Joanne Franco. And by all accounts, he is the person who is responsible for finances. He was the person responsible for operations. He was the person primarily responsible for dealing with CAS marketing and its principal, Ms. Stobadow. And at pages 203 to 207 of the record, it's clear he denies that the parties ever had a contractual obligation. He denies they breached the contract, and he denies that they agreed or ever would agree to be contractually obligated to pay CAS for consulting services to clients for which CAS was not providing any such consulting services. One of the things I want to stop at that is notable here is in this case, this is not a case where the parties had problems and the like. This was a relationship built on trust. This was a relationship that was incredibly positive. This is a relationship where CAS and Ms. Stobadow were paid millions of dollars over the years. But I want you to understand, this was not a case brought by Ms. Stobadow. This is a case brought after she passed away by the executor. At no time in the 3-year period, which covers all of the alleged damages here for summary judgment, in that period from the first quarter of 2013 through September of 2015, at no time did Ms. Stobadow ever suggest there had been a breach of the agreement.
Well, counsel, this is Judge Scarpula. Didn't you make a huge payment to her 10 days before she died?
Sure, payments were made along the way.
So that doesn't really say much when you're actually paying her lots of money during the period of time when you're saying she's not complaining.
So several things, Your Honor. First of all, relative. Thank you. Yeah. According to plaintiff's theory, though, we were in breach at all points. She never claimed we were in breach. Second, as the testimony is clear, we paid at various points in time because for a series of reasons, and there were accounts that she had procured, which is very different from the major accounts here where there was consulting. On the 3 biggest accounts here, which are over 70% of the damages, Disney, Lucasfilm, and Marvel, she had performed no services. She hadn't procured them. She hadn't helped in the renewals. She had done nothing.
Had you paid for them? Had you paid fees on those?
Yeah. So what the testimony is clear is not as a matter of contract, Your Honor. Not as a matter of contractual obligation.
Whether over the years you had been paying fees on those 3 things.
So absolutely, what the testimony is, absolutely.
Okay.
And what the testimony.
You can elaborate during your rebuttal time.
Thank you, Your Honor.
Mr. Pincus, you have 5 minutes.
Good morning, Your Honors, and may it please the court. During the relevant period, that's the most important concept for this court to remember when deciding this appeal. During the relevant period. This court should affirm the trial court's grant of summary judgment because defendants' admissions establish all the material terms of an implied in fact contract between the parties.
Mr. Pincus, there's an affidavit. There's an affidavit from one of the defendant principals who I guess is primarily responsible. He says no contract. How should we take that in consideration? Does that in itself raise an issue of fact in light of what you're about to say with respect to the admissions?
Well, no, it doesn't, Your Honor, because although he's arguing there's no contract, he doesn't contradict any of the material admissions that Franco made in this case. They established during their testimony and through request for admission exactly what CAS Marketing's role was during the relevant period, how CAS Marketing was supposed to be paid during the relevant period, and all the numbers needed to calculate CAS Marketing's pay for the relevant period. And during the depositions, first, Franco had produced its net sales reports for the licenses it held during and after the relevant period. Franco stipulated the date ranges of these reports and their accuracy and authenticity. That's at record 104 to 107. Then, at deposition, we walked defendants' principals through all 130 licenses in a chart arranged in alphabetical order. That's record 108 through 111. And for each license on the chart, we asked if CAS Marketing was the agent, the consultant, or neither on that license. And if defendant's principal testified that CAS was the agent or the consultant for that license, we asked when within the date range CAS was the agent or consultant and the commission rate for that date range. And if there was a discrepancy between Joe A. Franco's testimony, who's the vice president, and Joe N. Franco's testimony, we cleaned up the discrepancy by seeking the requests for admission, which are at record 112 and 116. These requests were extremely specific. For example, at record 113, number 8, we asked them to admit for the license listed on line 23 of the chart, which is Disney branded, and we gave the contract number and the Bates number, during the time period from 1/11/2011 to Cheryl Stobenow's death on September 4th, 2015, we asked them to admit that CAS Marketing's commission rate for that license during that time period was 0.8% of net sales. We did that 17 times, and basically through deposition testimony and requests for admissions, we got admissions that 84 licenses were credited to CAS Marketing during the relevant period, and they admitted to the commission rate for each of those licenses. And all of that was laid out on page 9 through 13 of our respondent's brief, as it was in our summary judgment brief, which is record 129 to 133. Now, Joe N. Franco's opposition affidavit doesn't controvert any of these admissions. He doesn't dispute that CAS Marketing was the agent or the consultant on any of the relevant licenses during the relevant period. He doesn't dispute the dates during the relevant period in which each license was credited to CAS Marketing as an agent and consultant. He doesn't dispute the commission rate or the net sales for any of the relevant licenses during the relevant period. Everything he argues about why there's no contract is a red herring. First, he says there can't be a contract because defendant Franco rejected certain proposed draft contracts in the 1990s. Well, that's irrelevant. We're not trying to enforce the terms of those contracts. We're only trying to enforce the contract and the terms that defendant's admissions establish were in place during the relevant period. It's the only time period that matters. They argue that there was no contract because the parties' relationship was somehow fluid or informal. But that doesn't matter either because defendant admitted exactly what the material terms were during the relevant period. And whether the terms were different before that, it's irrelevant. And nothing in Joe N. Franco's affidavit contradicts those material terms. They also try to argue they don't like the effect of the contract in hindsight. Franco's admitted that during the relevant period, it was supposed to pay CAS Marketing 0.8% of net sales on commissions for Disney and Marvel and Lucasfilm. And if there was any doubt about that, our request for admissions asked questions about both Disney and Lucasfilm, and they answered in the affirmative that indeed the rate of commission during the relevant period was 0.8%. Now, there are...
You have to wrap it up. You are out of time. I'll give you another 30 seconds.
Well, I'll just say that Joe N. Franco's affidavit doesn't controvert any of the material terms, and we've established, as in our brief, that there was a contract, plaintiff performed, defendant breached, and we've laid out all of the damages. Thank you, Your Honor.
Thank you so much. Mr. Ruskin, you have 2 minutes.
Thank you, Your Honors. I'd like to make 4 points. One, with respect to damages, $1.7 million of the damages are based on prejudgment interest. That's based on a contract finding that the monies were due on the end of each quarter. There is no evidence in the record to imply, in fact, a contract that payments were due on the last day of the quarter. In fact, all of the evidence in the record is to the contrary. Payments were made on account for the last many years. There's express testimony directly to the contrary. The practice is otherwise. There's no evidence of that. It was an implied, in fact, contract. There's no basis to find that until there was a judgment by the court. That would take care of $1.7 million. 2, with respect to the term or the duration of the contract, plaintiff shifts its positions at least 3 times. In its complaint, it said it was for in perpetuity. Then it shifted on summary judgment to say it was for lifetime of Ms. Stovenow. And now, in response to our argument that that would be problematic under the statute of frauds, which it would be, it now says it was terminable at will. So several things. Those 3 different versions certainly create factual issues. There's no evidence that it was terminable at will, but they have to prove that before the jury. There are at least factual issues as to that. If it wasn't terminable at will, there are statute of frauds issues.
Didn't Joe A. actually say that defendant reserved the right to terminate if performance by plaintiff was lacking?
So, Your Honor, he did say that in his view that the parties could end. There's no other testimony with respect to that. But if the contract could be modified.
Doesn't that mean that the it falls outside the statute of frauds? There's an exception.
But Your Honor, that's not what they found summary judgment on. They argued that it was for the lifetime of Ms. Stovenow. And what I would say to you, picking up on the last argument, if the contract can be modified.
30 seconds. I've given you an extra 2 minutes already. You have 30 seconds to complete your argument.
Thank you for the leeway. I appreciate that. What I was going to say is, if the contract can be modified, picking up on your last point, this is not a contract that says no modifications except in writing. To the contrary, if this whole contract was found by conduct. Clearly, the conduct over the last number of years was the position that Joe Franco said, which is we don't have to pay, there's no contract to pay for consulting services when there is no consulting. And there was no consulting with respect to the bulk of these contracts. And as to the request for admit,
thank you so much,
Mr. Ruskin. Denies all of that.
Thank you.
Thank you for the extra time.
No problem. Mayor versus General Electric, appellant Mr. Martinez, you have 5 minutes.
Good morning, Your Honors, and may it please the court. The trial court here misapplied the Securities Act tracing requirements based on its clear misunderstanding of SEC Rule 415. Its decision conflicts with precedent, and it effectively eliminates tracing as a requirement in cases like this one. If affirmed, that decision would make New York courts both an outlier and a magnet for meritless securities actions. Plaintiffs have failed to plausibly allege that they purchased their specific shares from GE in an offering that's governed by the challenged registration documents. They can't make this allegation because it's just as possible that their shares came from the open market, not from GE, and thus are not subject to the registration documents at all.
Counselor, is that a determination that should be made on a motion to dismiss? Isn't it sufficient for plaintiffs just to make the allegation that they need only show that the purchase shares issued are traceable to public offerings? That's all they have to do at this point?
No, Your Honor, and 2 points on that. First of all, the two best decisions and the only federal appellate decisions examining this issue come out of the Ninth Circuit, the Century Aluminum case, and the First Circuit, the Ariad Pharmaceuticals case.
Why should we ignore the Second Circuit?
The Second Circuit has not addressed that issue at all, Your Honor. It hasn't addressed the question.
Well, SDNY has addressed the issue, no?
There are a handful of cases in SDNY that have looked at it, and I think if you look closely at those cases, they don't have any of the level of analysis or reasoning as the Ninth Circuit decision or the First Circuit decision, which I think very clearly explained why it doesn't make sense to allow a plaintiff to just make a conclusory allegation of traceability. And I think
counsel, this is Judge Scarpullo. This is not a conclusory. There's no doubt that GE issued shares. And so the plaintiffs are saying, my shares were the shares that GE issued on the 415 registration statement. That's sufficient. This is not a heightened pleading requirement. This is that's a sufficient allegation on a pre-answer motion to dismiss. And you couldn't deny, in fact, you don't deny, that GE did issue shares. And we don't know at this point whether all the shares were issued by GE under any one of those 415 registration statements, because there hasn't been any discovery.
Well, I think, Your Honor, a couple of things. First of all, I think it's clear and it's undisputed that the shares could just have easily have been purchased from the open market. And we think that under the reasoning of the Ninth Circuit's decision, the First Circuit's decision, they clearly have to do more than plead the facts that they've pled. Really, what they've just done is just repeat the traceability requirement, just assert the element, and then say,
no, that's not really true, because they have alleged, and they have alleged that GE issues shares under these registration statements, and they bought their shares. So that is a different thing from saying there's no basis for this. There might be other shares, but there is a basis for this. And the Southern District has really, in more than one cases, said that's enough.
It's true that the Southern District has said that, but it hasn't done it with any analysis, anything close to the analysis of the only two appellate courts that have reached the issue. But I think that kind of probabilistic pleading theory is inconsistent with for example, the Fifth Circuit's decision in Krim, and also with common sense. I think if a plaintiff came into this court and said, I was hit by a bus on the highway and I'm suing Greyhound because they happen to have, own 80% of the buses that are driving on the highway, I don't think this court would say that that's a sufficient allegation. You need particularized.
This is Judge Scarpullo again. Let me ask you this. What if discovery shows that every single one of those shares were issued by GE and none were purchased in the market? Clearly, plaintiff would be able to trace. We just don't know that yet, and you haven't said anything about it. And there's no indication either way.
But Your Honor, and I think in the circumstance in which the plaintiff can't give an indication that he's actually able to satisfy the tracing requirement, that can't be good enough. That can't be good enough, because again,
all right, you'll have time on rebuttal. You have 2 minutes.
Thank you, Your Honor.
Ms. Quitt, you're up, and you have 5 minutes.
Thank you, Your Honors. Good morning. The court below correctly held that plaintiffs were participants in this GE stock direct plan, and they alleged that they purchased these shares directly from GE. Those standards are sufficient. They attached their confirms. All the documents show that this was GE's plan. These wasn't somebody else's plan. And these statutes, their motion was simply directed to standing. Now, as what happened in the court below, they like to focus on this Ninth Circuit summary judgment unreported outlier opinion. Now, in the first place, Ninth Circuit unreported opinions are generally not cited. And what was interesting about the Southwest Water case is that it was summary judgment, which addresses some of the issues that Justice Scarpullo was addressing, because what we know is what the plaintiffs have alleged, and they didn't come up with something that said, no, you didn't get these shares from GE. We have documents from GE that says this plan allows you to buy your shares directly from GE. There are documents in the record that say this is a way these shares were registered. So now we're in a pleading motion. The inferences go to plaintiff. They're asking the court to go completely outside the precedent of the Southern District, of the Second Circuit, on something that's peculiar. What's interesting also is, I think, knowing the weakness of that argument, they started to argue in the court below that their own transfer agent showed that they didn't get the shares from GE. That was their fallback position. A holding other than what the judge did below upsets agency law. These are well-founded principles. And in the Southwest Water case, on the pleading motion, the judge correctly found that the plaintiff did have standing. It was sometime later. Now, what's important about the Southwest Water case,
I'm going to give you 30 seconds. You're out of time.
Thank you, Your Honor. I appreciate it. Is that case relied on Century Aluminum. Century Aluminum makes clear that you only have to trace when you don't buy directly from the issuer. Your Honor, I appreciate the extra time.
You're welcome. Mr. Martinez, you have 2 minutes.
Thank you, Your Honors. First of all, just on the pleading standard, I do want to emphasize that the trial court did not decide this case based on the pleading standard argument and the pleading standard questions that have been raised by this court. Instead, what the trial court did in this case was create a sweeping rule that is quite extreme and essentially says that all of the shares transacted under the plan, even shares that came from the open market, would be traceable. I think whatever you do in this case, at a very minimum, I think you should make clear that that broad and extreme holding is just not correct. That even if this case were to get past a motion to dismiss, I think it's very important to make clear that they actually have to prove tracing. And what that means is that they have to prove that their shares came from GE. I think, secondly, Your Honor, even with respect to the pleading argument, I think it's very important to realize that the effects of allowing a conclusory allegation unsupported by facts to satisfy the requirement in this case, I think the result of that would be that any case is going to be able to get past a motion to dismiss. And I think it would put New York at odds with the Ninth Circuit and the First Circuit and the decisions of those cases, not just the unpublished decision in Southwest Water, but the published decisions in Century Aluminum and the published decision in Ariad Pharmaceuticals.
Thank you so much.
Thank you, Your Honor.
Okay, People v. Michael Wayman.
Good morning, Your Honor.
Will?
Good morning.
Good morning. You have 5 minutes.
Thank you so much. Good morning. May it please the court. Dana Wolf on behalf of Michael Wayman. I'd like to turn first to the statement suppression issue. And the question before this court is actually a fairly narrow one. And it's the same question that was squarely before the trial court. And that question is whether or not the prosecution carried its burden at the suppression hearing of establishing that Mr. Wayman was legally arrested when they presented testimony only from a detective who first encountered Mr. Wayman hours after he had been arrested, by which point he was in a police holding cell at the precinct and handcuffed. And I know that this court hears a lot of appeals that relate to suppression issues, and I know that your honors have presided over your fair share of suppression hearings. And so we all know that the types of issues that usually come up are factual issues, like what was the predicate for stopping the defendant? Was the defendant engaged in furtive movements? What was the description that the arresting officer had? Was it specific to the person who was arrested, or was it a generic description that could have been any one of 1,000 people in any borough on any given day? And I'd like to contrast all of those suppression hearing issues with what happened here. At this suppression hearing, the only officer who testified was Detective Hostetter, who was the officer who issued the I-card. Mr. Wayman was picked up by the police around 7 o'clock in the morning, and Detective Hostetter first encountered Mr. Wayman sometime between 10:15 and 11 o'clock in the morning. There was no testimony whatsoever, either from Detective Hostetter or from any other officer, because nobody else testified, about any of the things that courts usually hear at suppression hearings related to, who made the arrest, where the arrest happened, how the defendant was identified as the person to be arrested, how the officers behaved towards Mr. Wayman once they took him into custody, where the officers arrested Mr. Wayman. And on this point, I just want to, as this court knows, even with probable cause, there are very clear limits on what the police can do when they're arresting someone, particularly if that arrest took place at Mr. Wayman's home. And
did it take place in his home?
Your Honor, there is very strong indication that it did take place in his home. However, there was no testimony about the location of his arrest. Because Detective Hostetter, frankly, didn't know where he was arrested. There was one line of testimony at this.
Was that argument preserved? I'm just trying to remember. I don't. Was that specific argument with respect that he was arrested at home? Was that preserved?
Absolutely, Your Honor. I can read you some direct quotes. The very first thing that the trial attorney said to the court after the prosecution rested is, Your Honor, the statement must be suppressed because the people failed to meet their burden of going forward to establish the defendant's arrest was lawful, which is required under a Dunaway hearing. The DA failed to elicit the legality of the circumstances under which the defendant was taken into custody. The only testimony that described how Mr. Wayman was arrested was by Detective Hostetter, that he was picked up by the other officers from the warrant squad and dropped at the precinct. That's insufficient. And later, trial counsel then goes on to say, we have no idea what the arresting officers knew or they didn't know because they didn't testify. Did they pick him up in the state of New York, Judge? Did they violate Peyton when they arrested him? Did they break down the door to his house? We don't know, and that's part of the people's burden of going forward where Dunaway is hearing. And none of that testimony came out, which was all required in order to establish that Mr. Wayman was legally arrested. Respondent does not contest how significant the statements that followed Mr. Wayman's arrest were to his conviction, and there really is no argument. They were critical to his conviction. And so the sole question here right now is whether or not they were properly admitted when the trial court heard nothing about why Mr. Wayman was identified, what happened when he was arrested, and basically what happened in the intervening 3 hours or more after he was taken into police custody, let alone what happened in the 3 days between when the I-card was issued on February 28th and when he was arrested on March 3rd. Your Honors, I'd just like to turn very briefly to the CCRB issue, and I do have a timer going, so I will be mindful of my time. I know there's a lot on the calendar for Friday morning, but I also wanted to briefly touch on the CCRB issue. The trial court also improperly precluded defense counsel from cross-examining the officer who vouched the only shell casing that was recovered about a substantiated CCRB complaint. And that CCRB complaint found not only that the arresting officer had punched a person who he had arrested while they were handcuffed in the back of his police car until that person's orbital socket was fractured, but also that the officer was unreliable in the course of the investigation with the CCRB. And defense.
Ms. Wolf, I'm sorry, this is Justice Schulman. Was the casing critical to this case? Wasn't a very minor point given the overwhelming evidence?
Your Honor, respectfully, this was not an overwhelming evidence case. In fact, Mr. Wayman was acquitted of 8 of the 9 charges that were brought against him. He was only convicted of weapon possession. And here's why that shell casing was critical to the one thing that he was convicted of, because the prosecutor in her closing argument reread that officer's testimony about exactly where he found the shell casing in the snow next to a red car. And she reread his testimony about where the shell casing was, and then she showed the video where Mr. Wayman had made a statement on a different video saying that was identifying himself. And she says to the jury, remember this video? It's an evidence. And she tells them the shell casing means a gun was fired, which was relevant to 2 of the 4 things she needed to prove: the operability of the gun and the intent to use it unlawfully against another person. She rereads Officer Perez Romero's testimony about where he found it. And then she says, this is a red car on Washington Avenue, right in front of 1138. That's where the surveillance video is from. That's consistent with what Officer Romero said, where he found the shell casing. That's an evidence, and you can take a look at it. So, Your Honors, that shell casing was highly relevant to 2 of the 4 elements of what the prosecutor needed to prove in order to convict Mr. Wayman. And I will leave it there.
Thank you.
Thank you.
All right. Ms. Carlson, you have 5 minutes.
May it please the court, Cynthia Carlson from the office of Darcel D. Clark. The defendant's conviction for possessing a loaded firearm should be affirmed. His conviction rests upon overwhelming evidence, and his new claims on appeal are largely unpreserved, entirely meritless, and to the extent that this court may think there's error, the error is harmless. Focusing initially on the suppression hearing, Judge Iacovetta in this case, his decision, which is entitled to deference unless it's manifestly erroneous or plainly unjust, his decision was entirely appropriate. And I would point this court to a decision it reached not even a year ago in December of People v. Darrell Rose. In the exact same case, or in the exact same fact pattern, in the exact same court with Judge Iacovetta, and interestingly enough, with the exact same Detective Hostatter, testified that he issued an I-card, that after he issued an I-card, within 11 days, the defendant was arrested on the I-card, and this court concluded that the arresting officer did not have to testify at the Dunaway hearing because the testimony of the detective who issued the I-card mandated the inference that the defendant was arrested with probable cause by another officer based on the issuance of the I-card. Here, Detective Hostatter testified, he prepared the I-card, he disseminated it, and less than 4 days later, he was called to come into work early because his suspect had been apprehended. He also specifically said that Mr. Wayman had been picked up by the warrant team in regards to the I-card. As far as where the defendant was arrested, it doesn't matter in this sense because that's not what the hearing was for. This claim is unpreserved to the extent that the defendant is claiming.
Are you saying that if in this case, the police officers, notwithstanding having the I-card, show up at this defendant's house and break down the door, that would be okay?
No, we're not saying that was okay.
So I'm glad that you said no. That was the right answer. So if that would not be a permissible action, then how is the lack of any evidence on how he was actually arrested and where he was arrested, how does that satisfy the sufficiency requirement for the suppression hearing with respect to the Dunaway issue?
Because Dunaway is about probable cause. It is not about whether the defendant was arrested inside his home. That is a patent issue. And as the case law is clear, the people do have an initial burden at trial, or at the hearing, but we have to know what we're going to be litigating. And the only thing that the defendant requested was a Dunaway hearing in relation to probable cause in his motion. And as a result, the people are now being penalized that we didn't provide more information because we weren't required to do so. There's a conflation here between what Payton requires and what a Dunaway hearing requires. And turning briefly to the cross-examination issue, again, the court's decision to preclude defense from recalling a minor witness to cross-examine him on a collateral matter was a proper exercise of discretion. As defense even notes in their preliminary brief, the critical witness here was Detective Hostetter. It's not Detective Perez Romero. And Judge Iacovetta had 3 bases for rejecting the recalling.
Well, is the shell casing the one item that connects the defendant to this allegation?
No, in fact, it's not. What really connects the defendant to this allegation are the videos and his statement. So the videos show the defendant with the gun, and the video shows the defendant fire the gun and a muzzle flash. And then, as the prosecutor noted on her summation, when you look at the video, in the background after the muzzle flash, a person falls to the ground in the very location that one of the witnesses, or the witness who didn't testify at trial, one of the victims, was found by EMS and by first responding officers. So there is evidence outside of the ballistics. And importantly, the defendant was able to use Perez Romero's testimony to his benefit, because his entire argument was that this was a subpar investigation and that the officers did not lift a finger to do anything. And how do you know it was subpar, and how do you know it was made up? They can't even produce the bullet that was lost. It's a officer who found a ballistic, or excuse me, a shell casing that wasn't even submitted to ballistics because it was lost. Like, there's nothing about Perez Romero's testimony that was so critical that it would warrant a reversal of this conviction. And I would yield my time to...
You have no time left, but thank you.
Thank you.
All right. Ms. Wolf, you have 2 minutes.
Very briefly, Your Honors. First, if the burden of production means anything, it means there needs to be some basis for the trial court to decide that someone was legally arrested.
But counsel is correct. A Dunaway hearing is for the purposes of establishing what the probable cause was. Was there a Payton issue affirmatively raised by the defense?
Well, the defense said Payton repeatedly at the argument on the suppression hearing.
Counsel, but that's not how it works, and you know it. You have to make an omnibus motion seeking the suppression hearings that you want. And your hearing is limited to the issues that you raised in that omnibus motion.
Absolutely.
So in the omnibus motion, was there a Payton issue raised?
The questions that were raised in the omnibus motion were the legality of the arrest, the content of the description that the officers relied upon in identifying Mr. Wayman as the person arrested. And those were the issues.
Did the omnibus, I'm going to try one more time.
I'm not going to.
Because I was a defense attorney too.
Absolutely.
Did the omnibus motion specifically ask for a Payton hearing?
It did not, Your Honor. However, I just want to say that the key Court of Appeals case, which is cited in our brief, which is People versus Gonzalez, specifically considered the location of the defendant's arrest in the context of a Huntley-Dunaway hearing. That's necessarily part of the assessment of whether or not the arrest was valid. And I just want to turn. Thank you. Thank you, Your Honors.
Have a good day.
You too.
All right. Coronado versus Viola North America. Mr. Isaac, you have 5 minutes.
Thank you, Your Honor. Brian Isaac, it is, yes, the afternoon. I'm going to take far less than my 5 minutes because I think that I'm pretty sure you can decide this case without me talking a lot. Here's my argument. I'll give it to you in 40 seconds. And if you have no questions, let my adversary talk. You have an accident with a stopped car. You have an affidavit from the plaintiff. You have an accident report. I know there's a ton of discussion in the briefs about CPLR 4540A. But all you have to do is look at this case on burden of proof. Hitting a fixed accessorized car that stopped, not doing anything illegal by a hospital where the plaintiff is bringing her daughter from a dental appointment, establishes prima facie case of liability. And there's nothing contrary. There's an affirmation from Mr. Fixler, my adversary. He's a very good lawyer, but he attached a copy of the plaintiff's 50H transcript, which confirms everything that occurred. Under Rodriguez, I don't have to show absence of comparative negligence. I don't think there's any comparative negligence because the van wasn't moving. And in a case like this, there's no reason to forestall summary judgment because discovery is in its infancy. In fact, there's a very, very good reason with Rodriguez to proceed precisely like this. If you have a VTL violation or a violation of the rule of the road as a matter of law and you get summary judgment, the case tends to resolve because interest starts running. And then it's better for the court system and better for all concerned. So I don't see any contrary evidence. I think it's a perfect liability case. And I would ask you to reverse and grant me summary judgment. If you have no questions, thanks for listening to me.
Thank you. Mr. Fixler.
May it please the court. I think the threshold issue here is whether or not plaintiff submitted sufficient credible evidence in admissible form. Plaintiff's affidavit and the 58's transcript don't establish how the accident took place. In fact, if that was the case, they wouldn't be relying on the accident report. But they are relying on the accident report, and that's the seminal piece right here. We're talking. They submitted it saying that 4540 dictates, yet it was submitted by the corporate defendant who owned the vehicle, and it really is a vicarious tortfeasor here as opposed to an active tortfeasor. When they're trying to bind a party who they didn't establish who the historian was or who the declarant was, they can't bind my client to the statement made in that incident report. Absent being able to put that accident report before the court, all you're talking about is a plaintiff who said, I was standing in a vehicle and it rocked back and forth, and I believe there was an accident took place. But no testimony has been proffered from anybody to establish the circumstances surrounding the actual accident itself. The accident could have taken place in a number of different ways, and there's no evidence before the court to establish that at this point. Absent that, and absent plaintiff's counsel having done his due diligence, or
are you suggesting that there was some third party reason why the defendants here struck the bus?
Well, there's definitely an issue right now.
Because we know that the bus was stationary.
Yes, we do, Your Honor. And I appreciate that, but I also appreciate the fact that absent any showing that that vehicle was there for a reasonable period of time, and there is case law stating that even a vehicle who has license to stay in one of these places does have to actually move within a certain period of time, given what the circumstances of the traffic in that area are. And there's been no evidence to establish one way or the other because no deposition of that particular party has been taken at this point.
You're suggesting that there would be liability to a bus because they stayed at a bus stop longer than necessary?
I'm not suggesting it. The court's suggesting it. I'm merely going off what the court's saying, that in certain circumstances, a stationary bus can be found to be held liable if they are there for a period of time that's unreasonable given the circumstances surrounding the traffic in that area at that particular time. So I'm citing the court on that. I believe it was White v. Diaz, First Department, 2008. Okay. I cited that in my papers, and so I'm saying in that regard, given the fact that there actually is potential for there to be liability on someone else, at the very most in this case, plaintiff would be entitled to an order by the court stating that she was not culpably responsible for the accident, which is actually something that you and Judge Singh have both come down on. Even very recently, I think Owatanayu was it. You on Ramirez, Kaplan, Bufa, Campbell, Hedian. It was you, Judge Singh, that you all signed on to these. So I don't believe that plaintiff has actually established anything more than the fact that she wasn't a driver of one of these vehicles. I don't believe plaintiff's counsel has actually asked the court for summary judgment on the issue of culpable conduct. But if the court was to search the record and come up with any decision, it wouldn't be one on liability on the defendant at this point, because I believe that's premature, absent any evidence from both the active driver of my vehicle or the operator of the bus. But plaintiff, in fairness, has established that she was a passenger and not operating any one of these vehicles. So at the very most, there would be that finding, but nothing on liability on either defendants.
Okay, thank you so much.
Thank you,
Mr. Isaac, you have 2 minutes.
Yes, and I'll be brief, Judge. If you look at page 101 of the record, the plaintiff says that she was in a stationary vehicle. She was struck by a vehicle that was operated by the defendant. The defendant admits in the answer, I think it's paragraph 20, that they were stationary. And that's all you need. The fact that there may be some other phantom theory of liability against someone, which I don't understand, is irrelevant. You can have more than one proximate cause of an accident.
Was this bus properly stopped at a proper bus stop?
It wasn't a bus stop. It was an accessorized vehicle, and they were properly stopped. The plaintiff was coming from an appointment, a dental appointment.
Wait a
And
second, counsel, may I interrupt you? Wasn't the excessive bus double parked?
it was 5 feet away from the curb, is what they're
Well,
saying.
I read some information in the record that showed that it was double parked.
I think what he says, it's 111 of the record, Judge Scarpula. I'll read it to you. It's the bottom. I made a left turn signal from York Avenue onto West 70th Street to stop at Wild
Okay, so let me stop you there. West 70th Street, now we're at?
It's not, that's a mistake. It's East 70th. But he said about reading.
How is that reliable? Because you are relying on that for us to grant you summary judgment. That's not reliable at this point. It's not authenticated. Don't you think that discovery is necessary before you make that motion?
I honestly don't, because there's more to it than that, Judge Singh. And what he says is, I move right around the van to park in front of the loading dock, and the passenger side box, that means of his vehicle, contacted the van's driver's side mirror and front quarter. One plastic piece surrounding the headlight and the mirror were broken. The van was drivable, and the van driver left it. Passengers were not injured and left the scene. So,
Mr. Isaacs, who was the source of that statement?
Yeah, that's what I want to know.
it's unclear. It's certainly not signed, and I'm not suggesting to you it is. But 4540A.
So it's unsigned. No, and I don't have an issue with the authentication, but how much weight can we give that? We don't know who signed it. It has an error in it. No.
Well, no, but here's what I'm saying.
It's a drastic remedy, as they say.
I'm not relying on that alone. I'm relying on.
But so put that aside. Can you make out your case just on the affidavit of your plaintiff?
I believe I can, because it establishes that she was in a parked vehicle, that she was struck by another vehicle, which she identified. She identified Mr. Edens. She identified the license plate number, and she said that the striking.
But how does that make out? But how does that make out summary judgment? The fact that she was struck.
If she's in a stopped vehicle, you have held that a stop fixed object. If you strike a stop fixed object, there's liability. It's Bunn against the city of New York. It's my case. And there's a case called Sharpton against New York City Transit Authority, with the argument that there was a vehicle that was in the intersection that shouldn't have been there, didn't exculpate a left turning vehicle, because you can have more than one proximate cause of an accident. Cite on Sharpton is 136 AD 3D 712, Second Department 2016. And the Bunn site is 166 AD 3D 491. And that was a case with a fixed object on a road. And the defendant said.
Thank you, Mr. Isaac.
Your Honor.
Thank you, Your Honors.
All right. And the last case on the calendar, Mezanev versus Tashbekov. Mr. Mezanev, you have 5 minutes.
Thank you for making this possible. I consider it a small miracle that this is doable from my mom's apartment on the other side of the Atlantic. I'm profoundly grateful for the opportunity, and I have 6 points to make. Can you hear me all right?
Yes, we can hear you. You may proceed.
Number one, the lower court did not want to see the big picture and failed in wisdom. It is not wise to put the interest of a divorce attorney, the monetary interest of a divorce attorney, above the sustenance needs of a family. That is not wisdom, that is a stain. One cannot replace a parent with a divorce attorney. Parents are worth more than attorney's fees. Number two, this is a David versus Goliath situation. The respondent mobilized and manipulated the law enforcement apparatus of a state and unleashed it upon me. Multiple NYPD, ACS, armed police squad interrogations and home intrusions, one after another, for years. We started with shared custody in our separation agreement from 2015. We ended with shared custody in our parenting agreement from 2018. In the interim, a life was destroyed. 20 plus career gone. A job with 12-year tenure and the best performance of the firm gone. $2 million gone to attorneys for nothing. The lower court did not ask why. Number 3, when you're mystified, as the lower court determined it was, you ask questions, you invite experts, you resolve conflicting testimony. You don't suppress evidence, you don't suppress testimony, and you certainly don't award $100,000 to your friends who appear on a consistent basis in your courtroom. Number 4, the respondent perpetuates fraud as a way of life. To the federal authorities, she presents as a persecuted lesbian since age 4. To me, she presents as a straight woman in need of rescue. The defendant whitewashed her own crimes using the matrimonial system of New York State. She needed a secure anchor in this country. That is why she weaponized the child and scorched the earth to obtain sole custody. Justice says, I am paying for somebody else's crimes. That is not fair. With respect to the formalistic arguments of the opposition, I'm trying to do my best. I'm not an attorney, but even I can tell that the precedents that are cited do not go to the core of what drove this litigation. None of the precedents involve the whitewashing of immigration crimes using the matrimonial system and a US-born child as pawns. None of the precedents involved the moneyed spouse being driven into poverty and losing his livelihood as a result of the actions of the other spouse. None of the precedents involve attorneys and adjudicators who are friends with and admirers of one another. Most of the precedents involve people who are represented by professional attorneys. Number 6, the lower court confused spending with paying. The respondent does not have skin in the game because her attorneys have issued her a blank check. By doing so, they transmuted the litigation position of the respondent to the overwhelmingly advantaged. Brownstein and Zuckerman's purse became the respondent's purse. What you pay is what matters in terms of how constructive you are in litigation. You know this
You have
better
1
than I do.
minute left, sir. I just wanted to give you a warning, okay?
Thank you very much. I have paid for 97% of this litigation. I faced judgments, liens, and the full brunt of the law. In contrast, the respondent faces, the young, attractive respondent faces a virtue signaling male attorney. It is not hard to figure out whose skin is on the game. Many wrongs were done here, Justices. I ask that you undo one of them. As the documentary Erasing Family shows, tens of millions of kids grow up without their parents because sometimes divorce devolves into a patronage and a business, not an exercise in civic service and certainly not an exercise in wisdom. When you have a spouse's life turned upside down, under the auspices of a matrimonial court, marriage loses its value as a civilizing platform and becomes an extortion chamber for con artists and $700 per hour profiteers. Thank
you so much, Mr. Mezzanant. Thank you. Ms.
Brennanson.
Brennanson. I had to look at my sheet.
Good afternoon, Your Honors. Great. This is Connor Brennanson from Bronstein and Zuckerman representing the respondent, Bermet Tashibakova. And may it please the court, the subject of the appeal is not the entire life story or the life story of the divorce in this case. It is the decision and order of March 29th, 2019, which is an order for $100,000 of attorney's fees, interim attorney's fees in a matrimonial action. This is a reduction from what the respondent requested, which was $282,000. It's also significantly less than the amount that the appellant paid his counsel as of that time, as of the time of opposing counsel fees, which was the summer of 2018. He had paid his attorneys $337,000 approximately dollars to his attorneys. So the numbers there show what we're talking about at that time. And I think the main point is that on appeal, the court looks at what was the circumstances at the time of the decision, what was in the briefs, what were the arguments that were made, what facts were presented at that time. That was the summer of 2018. The judge made her ruling in March based on those facts. The appellant disagrees with the court's order. He cannot show any abuse of discretion, which is the standard of law on appeal. So instead, he turns to two tactics here. One, to say that since the order, things have declined for him. He had $2 million in assets at the time that the divorce started. He, according to his own record, had $1 million at the time that the judge made her decision. And since then, he's spent all of his assets. Looking at facts and circumstances that arise after the order and after all the briefing is contrary to the way the appellate division works, the way the civil judicial system works.
Ms. Berenson, this is Justice Shulman. Didn't the order provide for a potential credit in the plaintiff's favor when there's the eventual equitable distribution award, where theoretically he could get an offset of some kind as a result of this interim award?
Yeah, whether it's in the decision or not, it was definitely open and available because at that time the financial trial was being scheduled, and that was assigned to a special referee who could take into account and adjust equitable distribution, any further award for counsel fees based on what the prior orders were made. So yes, Your Honor, that was an available recourse. That trial already occurred. The special referee issued the report, and it has already been briefed before the Supreme Court as to whether to affirm or deny that. And the arguments that I lost visual of the court. Can the court hear me and see me?
We can hear you and see you.
Okay. So one principle of law is that the appellate court makes its decision based on information that was available at the time and not based on facts that arise afterwards. And at the time, it was fair. And there was no abuse of discretion. And then the second tactic of the appellant is to say that although he made 2 arguments in his opposition brief, now he has 6 new arguments. These arguments were never raised. He now argues excessive billing. That's nowhere in his briefs. He argues judicial bias. That's nowhere in his briefs, and so on and so forth. He argues that there's fraud, as he mentioned again today, and other abuses. That's not in his brief. You make your best argument when you submit your brief, and you don't get to make a new argument on appeal. That's the way our judicial system goes. Otherwise, judicial orders have no finality. If they can be reopened again with new arguments and new facts without end. And I would just like to say that the argument, the appellate, the allegations that he makes in his briefs not only are they not true, and not only should the court not consider them, but and I know that he's pro se, and so he gets some leeway, but he asked to supplement the record with his job search in a motion. The court denied it in the summer, in July, I believe. In August, in his reply brief, he puts paragraph and paragraph copying what he believed to be information from his job brief. So he wasn't allowed to submit it. He put it as an exhibit. He puts it inside the reply brief. It's just not complying with even the basic tenets of our legal system. He raises arguments that have already been raised and rebutted. For example, he argues that she hid money in an account offshore, and that argument was already rebutted in the first appellate, first motion for attorney's fees, and then it's raised again. And I mean, I could point to the page in here where it's just nonsense. He puts in he submitted the testimony, he submitted the evidence on the record, page 524, accusing her of hiding money for an account that shows, the bank account that he submits shows that there's no transaction since 2009, and the balance of the account is 37 soms. That's the money in Kyrgyzstan, which is like 50 cents. I mean, he's the grasping at straws. The allegations that just have no connection to the evidence.
Let's wrap it up.
That's what I have to say is please affirm the decision. Please disregard and strike all the information that is improper in both the briefing and in the briefs. And thank you, Your Honor.
Thank you so much. This concludes the court session for today. Thank you.
May I respond?
No, sir, you don't have any reply time. Our session for the day in court is now ended. Thank you for participating. Have a good day, all.
Thank you, Your Honor.
The court stands adjourned.